It's okay. You don't need cigarettes, you can still go to the other end. Lucas, you are number 3, eh? You can, the other one to be where babies. That's good. Will, can you help me? Okay, there. Exactly there. Now, assistant member of the press, I request you, we have not taken account. So, these are just investigations that were allowed by EACC accused persons in various capacities were charged with corruption offenses under the Anti-Corruption and Economic Crimes Act, the SECA, engaging in fraudulent procurement, contract provision with the Public Procurement and Asset Disposal Acts of 2015, PPADA 2015, as well as the laundry conduct provision proceed of crime and laundry acts number 59 of 2009. That's the OCAMLA. Firstly, the offense arose from the procurement process and award of tender to testimony enterprise activities delivered the accused person. Payments and movement of money in respect of tender number CGK, RTPW and U, oblique 142, oblique 2017 to 2018 for the upgrading of various roads within Kiambu County to bituminous standards and 20 cent. We'll refer this one as the road project, the question road project tender. We don't need to go on with the long abbreviation. So, secondly, just Enterprise Limited, the 11th accused person, for various contracts awarded under requests for quotations. Briefly, it was the prosecution case that 11th accused person, just Enterprise Limited, a firm owned by the couple, Charles Mbudia Chege, the fourth accused, and Bello Angeshmburu, the fifth accused person, won the question road project tender by engaging in a fraudulent procurement practice. The prosecutors already evident that accused Luca Mango Inya, alias Lucas, hereinafter referred to as Ignia Lucas, was at the material time the Chief Officer of Roads, Transport, Public Works, and Utilities as Kiambu County Government. He stands accused of using his office to improperly award the question roads project tender to Testimony Enterprises Limited. The other limb of the prosecution case concerns the movement of money from the payments to Testimony Enterprises Limited from the question road project tender and contracts under request for quotation to the bank account of entities associated with the first accused person, Waititu, and his wife, the second accused, Susan Wangari. Mr. Waititu, a renowned politician, was at the material time, as stated in the charges holding the privileged rank of an elected governor of Kiambu County. This is evidenced by the legal notice number 7845, dated 16th of August 2017. This Gazette notice bearing the legal notice was producing evidence as plaintiff number 142. The former government is blamed for conflict of interests by acquiring direct private interest in the payment made by Kiambu County Government to Testimony Enterprises Limited. By receiving monies through the bank accounts of the business entities like Waititu Estate Developers Limited, the accused, as well in Venue Delta Hotel, the accused, and the Naivasha Resort Limited. The prosecution accused evidence that the first accused was the director of Waititu Estate Developers Limited, and that the Venue Delta Hotel was a business name registered in the twin names of the couple Waititu and Susan. More so, ownership of the two business entities that meeted the case. Prosecutors already evidence that Mr. Waititu, Susan Chege, Testimony Enterprises Limited, Waititu Estate Developers Limited, and Venue Delta Hotel, the source of the public funds obtained from Kiambu County Government by the said Testimony Enterprises Limited. It was further presented that funds ended in the bank account of the said business entities associated with the former governor and Lake Naivasha resorts. Zakaria Jenga Mbugo, the sixth accused, Joyce Ngina Musioka, seventh accused, Simon Kabosho Kangede, eighth accused, and Salem Kashukia Wanjiku, ninth accused, and Samuel Mungai Mugo. 10th accused were members of the Tender Evaluation Committee. On the 24th of February 2022, these 5 accused persons successfully launched a petition, which was before High Court under Corruption and Economic Crime Division petition number E003 of 2022. Zakaria Jenga Mbugo and 4 others was the Director of Public Prosecution and 2 others. That petition challenged the prosecution in the present corruption case. The judgment was rendered on 6th of October 2022, and all the 5 individuals were discharged by the High Court. As such, count number 6 is now spent, so we will not be dealing with that count, and that gives the reason why those persons are not before this court. The matter then progressed on a full trial as again the 1st, 2nd, 3rd, 4th, 5th, 11th, 12th, and 13th accused person. And that the trial prosecution called a total of 32 witnesses, supported by documentary and electronic evidence. This court, in its ruling rendered on the 21st of September 2023, held that the remaining accused person had a case to answer and accordingly placed them on their defense. That is in respect of count number 1, 2, 3, 4, 5, 7, 8, 9, 10, 11, and 12. Judges and defended themselves by giving sworn testimonies. The governor also, the former governor also called one witness. Charges against accused persons. That's the charge against the remaining 8 accused persons. As stated in the substituted charge sheet, admitted on 16 November 2021, as follows. For count 1, offense of conflict of interests, conduct provision section 42(3 as read with the 48 of ASECA. Charge against Ferdinand Ndungu Waititu Babayao, alleged between 2nd July 2018 and 13 March 2019 at Kiambu County in the Republic of Kenya, being the governor of Kiambu County, knowingly acquiring direct private interest to which he received a sum of 25,624,500 in respect of payments made to Testimony Enterprise Limited for contracts awarded to the state Testimony Enterprise Limited by the Kiambu County government. Count number 2, dealing with suspect property, conduct provision section 47(1 as read with section 47(2)A and section 48 of ASECA. Charge against Ferdinand Ndungu Waititu Babayao and Waititu Estate Developers, particulars between 2nd July 2018 and 13 March 2019, Nairobi within the Republic of Kenya. Being director of Waititu Estate Developers Limited, received a sum of 12,410,500 from Testimony Enterprise Limited, while having reason to believe that the same amount was acquired from Kiambu County government through corrupt conduct. Count 3, dealing with suspect property, conduct provision section 47(1 as read with the 47(2 and 48 of ASECA. Particulars and charge against Ferdinand Ndungu Waititu Babayao and Waititu Estate Developers, particular being that on between 27th August 2018 and 27th September 2018, Nairobi within the Republic of Kenya, being the governor of Kiambu County, cost a sum of 6 million from Testimony Enterprises Limited to be paid to Lake Naivasha Resort Limited to be used as part payment of purchase of land reference number 209/2582, where Delta Hotel is situated, from Superior Phone Communication Limited, while having reason to believe that the said amount was acquired from Kiambu County government through corrupt means. Count 4, dealing with suspect property, conduct provision section 47(1), 2, and A as read with 48 of ASECA. Charge against Ferdinand Ndungu Waititu Babayao and Susan Wangari Ndungu, trading as Benvenue Delta Hotel, alleged that between 31st October 2018 and 3rd of January 2019, Nairobi within the Republic of Kenya, being proprietors of Benvenue Delta Hotel, jointly received a sum of 7,214,000 from Testimony Enterprise Limited, while having reason to believe that the said amount was acquired from the Kiambu County government through corrupt conduct. Count 5, abuse of office, conduct provision of section 46 as read with section 48 of ASECA. Charge against Luka Mwangi Waihinya, alias Lucas, particulars on 16th March 2018 within Kiambu County, being a person employed in the public service as a chief officer, roads, transport, and public works and utilities. You used your office to improperly confer benefits, to wit, the award of the question tender for grading of various roads within Kiambu County to bituminous standard worth the sum of 588,198,328 and 20 cents to Testimony Enterprises Limited, a firm that was irregularly procured. 7, engaging in fraudulent practice in a procurement, conduct provision section 66(1 as read with 2, as well as section 177 of the Public Procurement and Asset Disposal Act, charge against Charles Budhia Chege, Beth Wangeshi Mburu, and Testimony Enterprises Limited, alleged that on 26 February 2018 within Kiambu County, being directors of Testimony Enterprise Limited, engaged a fraudulent procurement practice to withhold submission of bid document in respect of the question tender to Kiambu County government, incorporating 4-degree certificate for the technical staff purportedly from the University of Nairobi and Jomo Kenyatta University of Agriculture and Technology. Count 8, engaging in fraudulent practice in a procurement. Contract Provision Section 66(1) as read with 77 of Public Procurement and Asset Disposal Act of 2015 particulars, and offense against Charles Mbudia Chege and Bedo Angeshi Mburo and Testimony Enterprises Limited, that on 26 February 2018, and Kiambu, being directors of that company, Testimony Enterprises Limited, engaged in a fraudulent procurement practice to withhold submission of a bid document in respect of the question tender by incorporating a fraud recommendation letter purportedly from China Wuyi Company. Count number 9. Fraudulent acquisition of public property under the provisions of Section 45(1). A, has read with 48 of ASECA, particulars and offense against Charles Mbudia Chege, Beth Wangeshi Mburu, and Testimony Enterprises Limited between 16th April 2018 and 11th March 2019 in Nairobi, within the Republic of Kenya, being the director of Testimony Enterprises Limited, a limited liability company, you jointly acquired public property. That is the sum of 147,274.55 shillings and 40 cents from Kiambu County government with respect to the contracts in the question tender for grading of various gravel roads to bituminous service at Kiambu County. 10, offense of money laundering, contrary to provision Section 3A. 1, as read with the 16 of Pokamla, particulars being that an offense against Ferdinand Ndungu Waititu Babayao, Sekatu Estate Developers Limited, Charles Chege Mbudia, Bedo Angeshi Mburo, and Testimony Enterprises. Particulars being that on the 2nd of July 2018 and 13 March 2019, Nairobi, within the Republic of Kenya, while knowing that a sum of 12,410,500 formed part of proceeds of crime, engaged in an arrangement for the transfer of the said money from Testimony Enterprises Limited to Sekatu Estate Developers Limited, whose effect was to disguise the source of the said money. Count 11, an offense of money laundering under provision of Section 3A1, as read with 16 of Pokamla, offense against Ferdinand Ndungu Waititu Babayao, Susan Wangari Ndungu, trading as Belvenue Delta Hotel, and Charles Mbudia Chege and Bedo Angeshi Mburo, and Testimony Enterprises Limited, say that between that 1st October 2018 and 18th of January 2019, Nairobi, within the Republic of Kenya, while knowing that a sum of 7,214,000 formed part of proceeds of crime, you engage in an arrangement for the transfer of this money from Testimony Enterprises Limited to Benvenue Delta Hotel, whose effect was to disguise the source of the said money. Count 12, an offense of money laundering under provisions of Section 3A1, as read with 16 of Pokamla, particulars and offense against Ferdinand Ndungu Waititu Babayao, Sekatu Estate Developers Limited, Charles Mbudia Chege, Bedo Angeshi Mburo, and Testimony Enterprises Limited, between 27 August 2018 and 27 September 2018, Nairobi, within the Republic of Kenya, while knowing that a sum of 6 million formed part of proceeds of crime, you engage in an arrangement for the transfer of this money from Testimony Enterprises Limited to Lake Naivasha Resorts Limited, whose effect was to disguise the source of this money. The prosecution case as presented against the accused person at the trial is as follows. First witness for the prosecution, Dr. Justus Bundi Kinoti, laid evidence that between December 2017 and October 2017, he was the director procurement at Kiambu County Government. The witness had distinguished procurement as supply chain specialist, done with the following professional qualifications: a PhD in supply chain management, master's degree in procurement, logistics, and a BA in business administration. He is also a member of the Kenya Institute of Supplies Management, KISIM, and Certified Institute of Supplies Management, CIPS. His duties at the county then entail coordination of procurement activities, issuing of professional opinion, coordination of disposal activities, proposal of members of various committees for appointment by the accounting officer, report to the regulatory bodies such as public procurement and regulatory authorities, updating the list of registered suppliers, and any other duty that may be assigned by the accounting officer. He was then reported to the Chief Officer Finance and Economics, Planning and Supervisor Procurement Officers in the 11th Department of Kiambu County Government. He set out the procurement process as follows: requisition by user department, approval of requisition by accounting officer based on the procurement plan and budget, communication by accounting officer to the procurement officer of the user department on choice of the procurement method based on threshold, communication to the director of procurement that advertising could be done, opening of bids by tender open committee if it's an open tender, and tender open committee is appointed by the accounting officer by the names proposed by the direct supply chain management. Evaluation, which is done by the evaluation committee appointed by the accounting officer, but the names are proposed by the director of supply chain management. Evaluation reports, which is forwarded to the director of supply chain management for his professional opinion. Then the director of supply chain management will then forward the professional opinion to the accounting officer. Then the accounting officer will then make a decision based on the evaluation report and the professional opinion, which is well elaborated under Section 80 of the Public Procurement and Asset Disposal Act of 2015. Then to be followed by communication by notification to both the successful and the unsuccessful bidders. And in the event the bidder is successful, a contract is entered within 14 days, and if there is no appeal, and that is if there is no appeal to the review board by any bidder. If there is a termination of the procurement process, the same should then be reported to the Public Procurement Review Board, which is a regulatory body. And if the bid was successful and there is no appeal, then the successful bidder would furnish the processing entity with a performance bond and enter into the contract. Then this contract should be entered within the valid period as indicated in the tender document. The execution process follows. If the tender was for good, the same should be delivered. And if the tender was for works, then it will commence after handing over of the site. And if goods and services, they will be then received by the inspection and acceptance committee appointed by the accounting officer. And following that, if it's good, then they'll be received at the warehouse and matter proceed for payment in the event of works. After inspection, the inspection and acceptance committee, a payment certificate raised, then the matter proceeds for payment. The procurement process of the tender, the road tender in question. It testified that the construction of the roads was a multi-year project which had been budgeted for the year 2017, 2018, 2018, 2019, and 2019, 2020. He referred the court to the budget booklet for the financial year 2017-2018, producing evidence as exhibit number 2. The tender in question was purportedly initiated through a cabinet paper that's dated 24th of January 2018. However, according to John Kilingi Mugwe, PW14, the County Executive Committee member for Roads, Transport, Public Works and Utilities, he denied that no such cabinet paper was tabled and or approved by the County Executive Committee, and that marked the initial flaw in the procurement process for these questions road tender. He then confirmed that the tender was advertised in the Daily Nation on 10th of February 2018, on the business day of 12th February 2018, as shown by the advertisement produced as exhibit number 3A and B. According to the advertisements, the bidders were required to download the bidding document from Kiambu government website, www.kiambu.go.ke. The tender was opened on 26th of February 2018 at 12 noon at the Ruiru Sub-County Boardroom, before the tender opening committee appointed by the third accused, Engineer Lucas, via the letter dated 23rd of February 2018, producing evidence as exhibit number 4. The members of tender opening committee were Nelson Wanjoy as chairman, Beatrice Wambeu secretary, Tabitha Maina member, Dennis Waruiro member, and Marion Canary member. It is the evidence PW1 supported by the tender opening meeting held on 26 February 2018 minutes, which were produced as exhibit number 5, that the tender attracted 5 bidders. The bidders were 1. Testimony Enterprises Limited, Yusha Consolidated Company Limited, and Chawins Limited, Decoys Construction Company Limited, and Wella Adi Holdings Kenya Limited. Next, the accused Engineer Luca then appointed a tender evaluation committee. By the letter dated 23rd of February 2018, members of this committee are Samuel Mungai as chairman, Secretary Zachary Mbugwa, Joyce Ngure member, and Samuel Ngatia member, and Salem Gashuka member. The Tender Evaluation Committee prepared the Tender Evaluation Report dated 5th of March 2018, produced as exhibit number 7B. Bundi made reference to the report. Plaintiff exhibit number 7B has stated that the Tender Evaluation Committee checked responsiveness against the criteria reproduced below. Contractor must be registered. That's for the criteria. Contractor must be registered under NCA. There is a signed and stamped form of tender, filling the confidential business questionnaire, valid tax compliance certificate from KRA, certificate of registration and corporation, 20% valid bid bond, signed and stamped pretender site visit certificate, serialization of the documents, litigation history of the company. The outcome of the preliminary evaluation on the aspect of responsiveness, according to the tender evaluation report, exhibit number 7B at page 4, only passed the bid by Testimony Enterprises Limited to proceed for the technical evaluation. The bid by Testimony Enterprises Limited was produced in evidence as exhibit number 9. The bids by the other 4 companies were rendered not responsive for the following reasons. 1. Bid by Yusha Consolidated Company Limited did not attach a bid bond, and therefore the company was not responsive. Their bid is exhibit number 10. Bid by Chawins Limited, which is exhibit number 11, did not serialize the tender document. Therefore, the firm was not responsive. Bid by Decoys Construction Company Limited, which was exhibit number 12, did not serialize the tender document, and that the bidder did not attach a methodology proposal. The firm was found not responsive. Bid by Wella Adi Kenya Limited, exhibit 13, had provided a bid bond of 1 million. The firm was not responsive. The bidder had also not serialized the tender documents. The firm was therefore not responsive. The Tender Evaluation Committee then proceeded to the technical evaluation and financial evaluation, and ultimately awarded the tender sum of 588, 198, 328, and 20 cents to Testimony Enterprises Limited. Dr. Kinoti maintained that the blank bid document produced as plaintiff exhibit number 8 was the reference point, and stated the criteria at page 29 of the tender evaluation. At that page, the listed 11 criteria were as follows: attach a copy of VAT registration certificate, attach a copy of business registration corporation, attach a copy of current and valid tax compliance certificate, attach a copy of registration certificate with NCA 5, grade 5 and above, proof of works of similar magnitude, adequate equipment and key personnel, proof of said financial standings, litigation history of the company, field confidential business questionnaire, and 20% valid bid bond. And the last criteria was pretender site visit certificate. According to Bundi, after making a comparison of the tender evaluation reports by the committee 7B with the blank bin bond XB number 8, he identified the following missing criteria. 1, proof of works of similar magnitude, adequate equipment and key personnel, and proof of sound financial standing. In addition, Bundi found that the tender evaluation reports exhibit number 7B and then applied criteria which were not part of the criteria in the blank tender document, plaintiff exhibit number 8. The two identified new criteria introduced were serialization of the document and the form of tender. The tender evaluation report, exhibit number 7B, was procedurally submitted to PW1 for his professional opinion. That is as per the statutory requirement of sanctioned by Section 47(2) of the Public Procurement and Asset Disposal Act of 2015. He produced his professional opinion as the exhibit number 14. The opinion was then addressed to the third accused, Engineer Lucas, the Chief Officer, Roads, Transport, Public Works, and Utilities. The overall observation by the head of procurement was that there existed gaps, and he recommended a re-evaluation of the tender in accordance with provisions of Section 46 of the procurement law. In response to the professional opinion, exhibit number 14, on the 5th of March 2018, Engineer Lucas made the following unwritten remarks in blue ink at page 4 of the document. Due procurement process has been followed to the latter. Few issues noted above cannot affect the outcome even after evaluation, and therefore I hereby award the tender to Messrs. Testimony Enterprises Limited, quote unquote, word of Engineer Lucas. The signature of Engineer Lucas below the above remarks was subject to examination by Stephen Yego, PW1, a forensic document examiner, and confirmed. The report is dated 24th of July 2019 and was produced as exhibit number 42, containing an exhaustive narration on the methodology and findings on examination. On my part, I find no reason to follow that opinion by Yegon that it is Engineer Lucas who had signed and made those remarks. Dr. Budi criticized the remarks by Engineer Lucas and testified that there existed gaps in the evaluation criteria and that the due procurement process was not followed to the letter. And at the trial, he pointed out the following anomalies. 1, the introduction of form of tender as a new criterion in the tender evaluation report, whose effect resulted to a disadvantage of bidder number 5, the Holdings Kenya Limited. 2, the introduction of serialization as a new criterion in the tender evaluation report, which resulted to a disadvantage to bidder number 2, Jusha Consolidated Company Limited, and bidder number 3, Chawins Limited. Bidder number 4, Dickways Construction Company Limited, and bidder number 5, Adi Holdings Kenya Limited. And at the same time, the introduction of serialization also gave an advantage to bidder number 1, that is Testimony Enterprises Limited. The second witness for the prosecution was Faith Njeri Harrison, PW2, Chief Officer in charge of Finance at Kiambu County Government, for the period between April 2018 to 30th of June 2019. Duties were strategic planning, budgeting, management of assets of the department, management of contracts, the department, preparation of financial department, keeping of books of accounts. In the year 2019, she was interviewed by ESCC officers and her testimony rested on the payment made to 11th accused person, Testimony Enterprise Limited, in respect of the question brought project tender and contracts and request for quotations. She identified 40 payment vouchers and the supporting attachment produced in evidence as plaintiff exhibit number 20, A to C, all the way to 60A to Q. A detailed analysis of these payment vouchers will be shown at table 1, which I'll be showing below. I don't know whether she's there. Yeah. Once I get the 80% to operate. Faith further testified that once an accounting officer is appointed by the Account Executive Committee member for finance, the signatures circulated to a department of the county government and the assembly. In that regard, she was able to identify the signature for the IE holder certificate on all the payment vouchers produced as plaintiff X number 2260, except for 29 and 38, which were that of the direct accused person. So that accused person, the one who had signed all the payment vouchers for the IE holder certificate for XB 20 to 60, except for 29 and 38. Beatrice Wambui Waithira was PW3. She's a supply chain management officer at Kiambu County Government, and on 23rd of February 2018, she was appointed by Engineer Lucas as the secretary of the tender opening committee and recorded the minutes during the tender opening on 26th of February. She tendered in evidence the following documents: the appointment letter, minutes of the tender opening committee, bid document for Testimony Enterprises Limited, bid for Jusha, for Chawins, for Decoys, and Wela Ali. The fourth witness was Dennis Wariro Duko, was previously working as a clerk officer at Road Department of Kiambu County Government. He was among members of the tender opening committee. His evidence tally and corroborates that of PW3 regarding the tender opening and marking of the bid documents. Samuel Njuguna Karanja, PW5, the Deputy Director ICT at Kiambu County Government. He is a certified information technologist. He acted as on ESCC requests and retrieved blank bin document for the question tender, which was produced as XB number 8. The document had been archived in a code web of Kiambu County Government for safe storage. He is the one who did the serialization of the documents from pages 1 to 213 and prepared an electronic certificate produced as XB number 8A. Thereafter, he handed over the bin document, the electronic certificate, to Kuto Kipruno of ESCC and signed an inventory produced as XB number 8B. Martin Bugwa, PW6. You can precast table 1. Is the county secretary of Kiambu County Government. He identified and produced in evidence the notification of award of tender to Testimony Enterprises Limited, dated 16th of March 2018 as plaintiff X number 9. He also witnessed the signing of the contract between Kiambu County Government and Testimony Enterprises Limited, dated 16th of March 2018, produced as plaintiff X number 61. He testified that he witnessed the signature of the other accused, Engineer Lucas, the Chief Officer, Roads, Transport, Public Works and Utilities, and also sealed the contract. The County Secretary further testified that he was the custodian of all cabinet memos, papers and minutes. He testified and maintained that the cabinet paper titled Proposed Improvements of County Gravel Roads to Bituminous Standards using soil stabilization technology, dated 24th January 2018, was not presented before the cabinet for approval. 7th witness for the prosecution was you open which one? Table of flowcharts, Pass of Mombasa. He testified that he was working as a clerk of works at Ronald Ngala Utalii College in Kilifi. He recalled that ESCC officers question 9 at page 272 and 274. So those documents of Kaze are there, but he said that he was not working for that company. Albert Kulumbu Ngome, PW8, a clerk of works at Mamangina Girls, Mombasa, and a higher diploma building and civil engineer from Technical University of Mombasa. Gave evidence that during the trial he was working for Mamangina Girls, Mombasa as a clerk of works. He was interrogated by ESS officers about a copy of his certificate and CV appearing on the bin document for testimony in the Pleads Limited. The bid for testimony is plaintiff X number 9. And those documents appears at page 276, 278, 279, and 285. He was catalogued that he never worked for testimony in the Pleads Limited and that he was not aware of the road construction works at Kiambu County. The 9th witness was Evans Mwinzi Mbuva, a senior assistant registrar in administration at the University of Nairobi. He was tasked to reply to the inquiries in the letter by ESCC dated 26 June 2019 regarding the verification of the following academic certificates. Copy of certificate for Vincent Omondi, number 3871. Copy of degree certificate for Frederick Omondi, number 7871. Copy of degree certificate for Paul Kandia Chumo, number 7171. Copy of degree certificate for Evan Nganga Ngumbi, and a copy of degree certificate for Nelson Kungu Gituku, number 3031. During the verification, he checked on the graduation booklets, student management information system, and made the following findings. 1. Vincent Omondi did not graduate on the 18th graduation ceremony at the University of Nairobi, held on the 18th of November 1989, and his name was also missing in the student management system. He also observed that Fred Omondi did not graduate on that first graduation ceremony of the University of Nairobi, held on the 17th of May 2004 at 9:30 a.m., and his name was also missing in the student management system. He also observed that Paul Kandia Chumo did not graduate on the second graduation ceremony of the University of Nairobi, held on the 11th of March 2005, and observed that the second graduation of the same year was held on the 33 graduation ceremony of the university, which was held on 14th of October 2015. He also checked and found that the person's names were also missing, and the names were missing the graduation. The person was not in the graduation, and his names did not appear on that graduation list for the year 2005. The name was also missing in the student management system. For Evans Jeroge Lumbi, he was not in the graduation list for the two graduation ceremonies held in the year 2007. And also his name was also missing in the student management system. For Nelson Kungu Gaduku, the degree certificate indicated that he graduated on 17th of October 2008. In that year, the University of Nairobi held two graduation on 17th of October 2008 and on the 19th of December 2008. On those two graduation, Nelson Kungu Gituku had graduated on that university. That was on 17th of October 2008, and his admission number was F16 2016 of 2002. The findings by the senior academic registrar contained in the letter dated the 3rd of July 2019 produced as plaintiff X number 63. He also produced evidence that transcript for Nelson Kungu Gaduku, which are XP number 63, A, B, C, D, and E. Dr. Esther Lara Moria was PW10, a registrar academic affairs at the Jomo Kenyatta University of Technology, JQ Arts. She was the custodian of certificate, transcript, and graduation lists, and then other academic records. She was tasked to reply to ESCC letter of 26th of June 2019 regarding the verification of a copy of BSc Mechanical Engineering course bearing the name of Patrick Kimani Gitonga, issued on 16th of July 2008. And upon verification, she found that Patrick Kimani Gitonga was not in any records of JQ Arts. These findings are contained in the letter dated 2nd of July 2019, produced as exhibit number 65. Luo Zeng Cheng, it's Lu Zicheng, PW11, gave evidence that he was the deputy general manager at China Wuyi Company. That company is specialized in construction industry and situated in Nyangumi Road, off Sayana Road in Kilimani. He was tasked to reply to ESCC letter dated 27 June 2019, produced as exhibit number 69, with regard to the verification of the copy of a letter dated 24th of March 2015, allegedly authored by one Yen Chan, produced as exhibit number 67A, and a completion certificate. The letter dated 24th March 2015 and the completion certificate are attached to the bin document submitted by Testimony Enterprise Limited at page 257A and 257B. He disputed the letter and completion certificate and the alleged author, and he said that the alleged Yu Chiu was not an employee of China Wuyi Company Limited. He testified that China Wuyi Company did not sign a subcontract with the Testimony Company Limited. To support his testimony, he presented evidence in the letter bearing the reply dated 28th of June 2019 and a sample letterhead for the company, list of employees for the Suna Masava Keanja C13 project, and contract document for the C13 project as exhibit number 68, 68A, B, and 69. Stephen Denya Mwangi, a human resource management and development officer at Kiambu County Government, was PW12. His duties entailed the earlier management of employee records. He presented evidence the personal file in respect to the other accused, Engineer Lucas. This file was produced as exhibit number 73 and bears the accused person's personal number, as well as the designation of a Chief Officer, Road Transport, Public Works and Utilities. Felix Naftali Mutedia, PW13, a clerk officer's business registration service, was tasked to conduct search of companies from request by ESCC contained in the letter dated 3rd of April 2019. The company of interest to the present proceedings, the 11th accused person, Testimony Enterprise Limited, and a letter of reply dated 10th of April 2019. The business registration service made the following findings regarding Testimony Enterprise Limited. A finding on its registration number: the company notified returned as at 10th of April 2019. Names of the directors were Charles Chegembudia, holding 10 ordinary shares, and Bedo Wangeshimburu, holding only 1 share. The company was registered on 9th of June 2011 with offices at Ronangara Street in Nairobi. Saranjari Ndungu was tasked by ESCC in the letter of 7th May 2019 to conduct a search on the 7 companies, among them 12 accused. Sekatu Estate Developers Limited is the company of interest, as well as the 13th accused, Benvenue Delta Hotel. She then wrote a reply letter dated 9th of May 2019, produced in evidence as plaintiff exhibit number 89, and made the following findings. 1. Sekatu Estate Developers Limited was a company registered on 24th of May 2011 with its offices in Jiru, Kangundo Road. The number of registrations indicated. Name of directors were Monica Jerindungu, director and shareholder, holding 980 ordinary shares. Advena Ndungu Waititu, director and shareholder, with 20 shares. In respect of Benvenue Delta Hotel, the company was registered as a business name on 14th of June. The registration number is indicated. It's located at Jiro Estate in Nairobi, Kangundo Road. Nature of business and hotel. Proprietors are Susan Ongari Ndungu and Ferdinand Ndungu Waititu. The 14th witness for the prosecution was John Mwangi Mugwe, currently a businessman, a politician, who was previously the County Executive Committee member in charge of Department of Roads, Public Works, Transport and Utilities at Kiambu County Government from November 2017 to April 2018. His duties included the presentation of cabinet papers before the County Executive Committee for deliberation. It was his evidence that upon his appointment, the governor implored upon him to consider new ways of making roads. He then embarked on a research on the matter and came across a letter dated 6th of July 2016, and the Road Standard Circular number 1 of 2016 produced as exhibit number 90 and 90A. The circular required the approval by the Ministry of Devolution of any new technology by 2018, produced as exhibit 94, seeking advice from the County Secretary when the cabinet paper will be tabled. However, the cabinet paper was never tabled before the County Executive Committee. In that regard, the testimony of PW14, which corroborates evidence of Martin Jogumbogwa PW6, that the cabinet paper for the proposed improvement of county gravel roads to bituminous standard using soil stabilization process was not tabled and approved by the County Executive Committee. He only learned about this he only learned about the advertisement of the tender in question in March 2018. That was before leaving the department on the 3rd of April 2018. In the end, that witness produced in evidence a printout of the circular number 1 of 2016, emailed and draft cabinet papers, which we have referred, as well as an electronic certificate. On cross-examination, he insisted that it was wrong for the tender to be advertised and awarded before the cabinet paper was tabled and approved by the County Executive Committee. Peter Karanja Jenga, PW15, a senior superintendent engineer at Kiambu County Government, was initially taxed by the direct accused person, Engineer Luka, to peruse and edit the blank bid document with respect to the tender in question. Thereafter, he was appointed the resident engineer for the question road project. His duties entails collection of data to help in preparation of the works program for the Department of Roads, Transport and Public Works and Utilities, supervision of ongoing construction, taking measurement of completed works and preparation of payment certificates. The resident engineer testified that Testimony Enterprise Limited was the contractor and commenced the works of upgrading the 10 Maram road to bituminous standard on the 16th of April 2018. He described the road construction work as a big project whose payments were processed by interim payment certificates in accordance with bill of quantities. The contractors team and the supervisor team were supposed to do joint measurement on the ground, which was tabulated against the rates quoted in the bill of quantities. The crucial aspect of the engineer's evidence was on the approval of the interim certificates. He gave evidence that 3 interim certificates were raised by the contractor, and he signed all of them. In particular, the resident engineer confirmed that he signed the interim certificate number 1 for a sum of 88,458,222.39. That certificate dated 30th of May 2018. The certificate is attached as a supporting document to the following payment vouchers. Payment voucher number 2316, plaintiff X number 25, for a sum of 22 million. Payment voucher number 2461, exhibit 26, for a sum of 22 million. Payment voucher number 2462, exhibit 27, for a sum of 22 million. Payment voucher number 2463, exhibit number 28, for a sum of 22 million. 458,222.39 cents. The 16th witness for the prosecution was Joseph Kamau Dande. The 16th prosecution witness Joseph Kamau Dande, previous a senior accountant at Kiambu County Government. At the examination section of the Finance Department, he confirmed that he signed the majority of the payment voucher in favor of Testimony Enterprise Limited, except for the 7 payment vouchers signed by his assistant, Daniel Maina. Henry Mburu Waweru was PW17, as well as Anna Jerichege, PW18, as senior officials at the Finance Department of Kiambu County Government. assigned the role of the second approvers in the internet banking system, and at the trial, both PW 17 and 18 produced in evidence the payment vouchers paid in favor of Testimony Enterprises Limited. Henry Mburu Waweru, Director of Revenue County, Revenue at County Government of Kiambu, was testified that he could only authorize the payment after the voucher is signed by the accounting officer, who also doubles as the AE holder, and the same has been examined and voted. He confirmed that he had approved the following payment vouchers in favor of Testimony Enterprises Limited. The voucher shown exhibit number 23, 21, 22, 24, 20, 25, 30, 33, 34, 35, 36, 38, 39, 44, 46, 49, 50, 51, 52, 53, 54, 5, 6, 7, 8, 9, 60, up to Q. And now it's easier, you can follow them. You can be able to follow them from the screens. Fuana Jerry, who was previously the acting deputy director account at Kiambu County Government from December 2017 to June 2018, she confirmed that she authorized the payments of the following payment vouchers in favor of Testimony Enterprises Limited: 26, 27, 28, 31, 32, 37, 40, 41, 42, 43, 45, 47, 48, and 29. I now go to the testimony of the 19th witness, Jacob Mashara Ndenya, an Assistant Director of Accounting Services at the Finance and Economic Planning Department of Kiambu County Government. He was the first approver in the internet banking system and confirmed that he approved the following payment vouchers: 29, 26, 27, 28, and 32, as well as 37. You can follow them from the screens. I now go to the testimony of the 21st witness, Lijodo Kihama, currently an advocate in private practice, previous senior legal officer at the head office of Equity Bank Limited, confirmed with the duty to ensure compliance with court orders on 16th of May 2019. The bank was served by ESC investigator with a warrant issued in miscellaneous application number 1836 of 2019 to investigate the bank accounts held by Testimony Enterprises Limited. The application supporting affidavit and the order are produced in evidence as exhibit number 96, A, B, and C. In turn, he retrieved and issued to ESC investigator the following document in respect to Testimony Enterprises Limited: account opening application, computer printouts, certified copies of the following checks. Checks produced at 97-1 and 97C1 and 97C2, 97C3, 97C4, 97C5, 97C6, 97C7, 97C8, 97C9, 97C10, 97C11. He also gave certified copies of the following applications or forms for funds transfer. Produces 97D1, 2, 3, 4, 3, and 4. You'll be able to follow and see them from the screens. Additionally, you also received from ESCC investigators an application warranty issued in another court case with supporting affidavits and order, produced as exhibit number 98, 1B and C, requiring him to investigate, to conduct investigation in respect of the account held by Charles Chege Mbudia and account held by Bedu Angeshe Mboro. He thereafter issued the following documents: for the accounts of Charles Chege Mbudia, certified copies of account opening documents, printout of bank statements, funds transfer, 99C1, 97C2, C and C3. For Bedu Angeshe Mburu, he gave a statement of the bank account, produced as exhibit number 100. On 20th of May 2019, he also received a further warrant to investigate as per Exhibit 101 ABC. The warrant request for document in respect of account name, Benvenue, BN, Venue, Delta Hotel, as well as account number for Lake Naivasha Resort Limited and account name 3 Management Services Limited. Pursuant to that warranty, he issued the following documents for Lake Naivasha Resort Limited, Exhibit 102A, and printout of statement, certificate copies of account opening form, as well as printout 102B. For Bienvenue Delta Hotel, certificate copies of account opening documents, computer printout of the statement, exhibit number 103A and B. Then on 29 May 2019, we also received another warranty. In that case, miscellaneous application 2259, requiring him to issue certified copies of account opening document and statement for 62 accounts. Account relevant to these proceedings is that of Sekatu Developers Limited. He then issued the following documents: copies of account opening document 105A, statement 105B, funds transfer 105C. There was also another account, but that one for Monica, who is not a party here, that's Exhibit 106. Then on 7 May 2019, he also received a warrant issued in miscellaneous application number 900 of 2019. The warrant and order required the bank to issue the investigator with the account opening documents and account statement for account name, Ferdinand Waititu. He then issued the documents, plaintiff exhibit number 108, plaintiff exhibit 109, which is the statement. Certified copies of following funds transfer, producer 108C1, funds transfer produces 108C2, funds transfer produces 108C3, funds transfer produces number 108C4, funds transfer produces 108C5, C108C16, 108C17, 108C8, 108C9, 108C10, 108C11, 108C12. Lastly, he produced in evidence the electronic certificate, which is exhibit number 109, to authenticate the computer-generated documents that he was producing. The 22nd witness was Wilson Boru Kamau, an employee of defunct NTF, in charge of safety and investigation, was tasked to act on the letter by EACC, producers 110, request for verification from Parastatal database, the identity cards issued to Ferdinand Waititu, then what for Kiambu County government, where the dependents were shown for that. This information was captured in plaintiff exhibit number 111 by Nicodemus Ocheng. That letter was produced by Nicodemus Ocheng Ondogo, 2018, showing the registration particulars of Mr. Waititu. Similar evidence on the identification of the first accused person and his nuclear family members was given by Job Kevin Mugo Maina, a registration officer based at NSSF building, Block B at 5th floor. He was able to do a verification. I'll not show a lot of particulars for purpose of the personal secrets of the accused person, but it is there. That's why I'm jamming some of those particulars. And I think that is in according with the law. We don't need to demean one's family members or put them into the public limelight, but stay in the judgment for the councils. But for this one, I'm jamming some of those particulars and even some of those accounts for protection of the persons who are being named. Now, he produced the letter plaintiff exhibit number 123, and a letter dated 3rd of June 2019, forwarding the printouts as exhibit number 128, which is a certificate of electronic evidence. The 23rd witness was Joseph Wangombe Wamuyu, land registrar based at Thika Land Registry, previously based at Ade House in Nairobi, was assigned to act upon the letter by FCC of 12 June 2019, addressed to the PS Minister of Lands. The letter sought to verify registration details and ownership of parcels of land, Nairobi Block 105, 8850, Nairobi Block 105, 8851. He then retrieved files in respect of the two parcels of land. For 105, 8850, the search shows that the land is still in the name of Winnie Wangeshi Mainda. For block 105, 8851, shows again the name of Winnie Wangeshi Mainda as still the registered owner. Leonard Kipseme was PW24, employee of Central Bank of Kenya. In the Banking Services Division, testified on the payment process via the IFMI system and Internet banking system. Was tasked to act upon the court order issued in Miscellaneous 2387 of 2019. The order requests for document respect of accounts, two accounts at the central bank, both held by the county government. You'll be able to see the two accounts. Then he was able to provide the following documents: account statements, the two account statements, and an electronic certificate. The letter confirming the opening of the bank accounts is addressed to the Transition Authority and communicates the opening of the accounts for the Kiambu County government. The letter is dated 25th of March 2013 and was signed by Mr. Mark Lesit, Director of Bank Services. Copy of the same was produced as 118. A band of 36 certified mandate cards for Kiambu County government officials authorized to operate the accounts, both accounts between 1st January 2013 and 1st May 2019 was also produced in evidence as XP number 119. Rahab Muihaki Karoki, a business lady based in Nairobi, testified that she was the chairman of Superior Hotels, which also owns Lake Naivasha Resorts, Masada Hotel, Elesa Hotel, and Paris Hotel. Rab confirmed that she was the previous owner of the Delta Hotel, situated on parcel of land LR number 2092582 along University Way in Nairobi City, which was sold by a company to Superior Phone Communication Limited to Seika2 Estate Developers Limited for a purchase price of 380 million. She tendered in evidence a sale agreement, exhibit number 120, a certified copy of transfer agreement, exhibit number 121, to support the said transaction, and identified the first accused person, as well as Mankanjeri, as the representative of the purchaser, that Seika2 Estate Developers, who executed the sale agreement. Rab confirmed that she received the following payments toward the settlement of the purchase price: a sum of 38 million, reflected on the statement at page 39 of 47, 12 million on 10th of March, reflected again on the statement at page 43, on 4th of April, 14 million, reflected on the statement at page 47, 5 million on 12th of April reflected in the statements. On 12th April, sum of 31 million reflected at page 3 of the statement. Then sum of 193,400,000 also reflected at page 7 of the statement. On 30th of April 2018, sum of 6,600,000 reflected in the statement. Sum of 3,500,000 reflected the statement at page 11. 5 million on 14th June reflected in the statement. On 20th June, 5 million reflected at page 19. On that July statement paid on 25th July. 27th of August, 3 million. 27th of September, 3 million. 2,528,000 on 6th of October. 1,477,000 on 6th of October. RAB then testified that accused person, Mr. Charles Chege Buya, was the owner of Testimony Enterprises Limited and was previously known to her and was working for Mr. Waititu. RAB also testified that Chege informed her that the payment made on 27th of August 2018 and 27th of September 2018 by Testimony Enterprises Limited for a total sum of 6 million was part payment for the purchase of Delta Hotel. On re-examination, RAB testified that the first accused called her to confirm the payments made by Testimony Enterprises Limited. Alex Nyandwi, PW27, a digital forensic analyst working for ESCC at the forensic laboratory, testified that he was trained in the use of IFMI system by IFMI's Department, the National Treasury, and granted read-only attest rights by the letter dated signed by the Cabinet Secretary, National Treasury, dated 1st of March 2018. The said letter was produced as plaintiff exhibit 125 and is attached to the report. That was produced by the witness. The role of the digital forensic analyst in the investigation was then to retrieve data from the IFMI system on payments paid by Kiambu County Government to Testimony Enterprises Limited. At the trial, Alex was producing evidence the following documents: the authorization letter 125, electoral certificate 126, IFMI supplier details and bank account details for Testimony Enterprises Limited 126A, IFMI's invoices from Kiambu County Government to Testimony Enterprises Limited 126B, IFMI's payment for Kiambu County Government to Testimony Enterprises for a sum of 221,489,800. That is at the appendix, which is exhibit number 126C. Charles Monica Mount was a PW29, Director of Chawins Limited, a binder for the tender. At trial, he identified the bin document for his company, Exhibit 11, and denied that he was ever notified whether he won the tender or not. He stated that the letter dated 8th of March 2018 by Kiambu County Government, produced as exhibit number 16, was only shown to him for the first time when he was called to ESCC offices. Zachary Odera is the of Supplies and Procurement Management from JQ Arts. In March, he was appointed by ESCC to lead a team of investigators to examine an anonymous complaint regarding the irregular award of tender by the county government, Kiambu, to Testimony Enterprises Limited. In the course of the investigation, the team wrote and received reports from various government institutions and made an application to the court for warrant to investigate bank accounts of the suspect bank and county government of Kiambu. He also obtained documents from the county government of Kiambu and interviewed the suspect as well as a prosecution test. According to the lead investigator, there was irregular award of tender to Testimony Enterprises Limited and loss of public funds. An important aspect of the investigation was the recovery of the certified copies of the requirement plan. And the financial year 2017-2018 budget of Kiambu County Government produces plaintiff exhibit number 2. It provided for an allocation of a sum of 202,367,000 for the road projects. The lead investigator and his team compared the blank bin document, exhibit number 8, with the bin submitted by the 5 companies and the reports by the Tender Evaluation Committee dated 5th March 2018, produced as exhibit number 7B. From this document, the investigators were able to establish that the Tender Evaluation Committee introduced the following 2 new evaluation criteria that were not the blank bin document at page 29. 1, serialization of the documents, and 2, signed and stamped form of tender. According to the lead investigator, the new criterion disadvantaged the other 4 bidders and gave undue advantage to Testimony Enterprises Limited. The lead investigator supported the professional opinion by the Director of Procurement, PW1, dated 5th of March 2018, produced as exhibit number 14. That there were gaps in tender evaluation reports, exhibit number 7B, and recommend that the gap be addressed in accordance with Section 46 of the Public Procurement and Asset Disposal Act. The investigator faulted the other accused, Engineer Lucas, for disregarding the professional opinion in respect of the tender evaluation report dated 25th of March 2018, produced as exhibit number 7B, and proceeding to award the tender to Testimony Enterprises Limited at a tender sum of 588,198,328.20. The lead investigator relied upon the finding of the forensic document examiner that the other accused, Engineer Luca, was the author of the tender notification letter dated 8th March 2018 to Testimony Enterprises Limited, produced as plaintiff exhibit number 19. The investigators also conducted forensic investigation on the bin documents submitted by Testimony Enterprises Limited, produced as plaintiff exhibit number 9, and discovered that the company had attached in the bin document the following false documents. 1, the CV of one Albert Ngome Kaluma, exhibit 9. 2, CV for Kanzea Joseph Mukari, exhibit number 9. Copies of degree certificates in the name of Vincent Ochengo Mondi at page 301 and 307. The one for Frederico Mondi, Paul Kandi Chumo, and for Evan Rog and Dambi. These certificates were purported to be issued by the University of Nairobi. According to Evans Mwinzi Mbova, in the letter dated 3rd of July 2019, number 3 confirmed that the certificate for Vincent Ocheng Omondi, Frederico Omondi, and Paul Kandi Chumo, and Evan Rog and Dambi were forgeries and not originate from the University of Nairobi. The other document was number 4 was BSc Mechanical Engineering for one Patrick Kimani Gitonga. The same was found to be a forgery by Dr. Esther Dara Moria, PW10. Uru produced the letter exhibit number 65. The 5th document was a completion certificate by China Wuji Company Limited, attached at page 257B, dated 24th of March 2015. Was also found to be a forgery as shown by the company letter, produced as exhibit number 68. The investigators also established that federal payments were made from the Kiambu County Government of coffers to Testimony Enterprises Limited in respect of the Question Road project as follows. 1, the county government of Kiambu paid 10% of the contract sum, which equals to 58,819,303,000 for notification fees. The same was meant by payment vouchers authorized by the other accused, Engineer Luca, in his capacity as Chief Officer and the AE holder for the Department of Roads, Transport, Public Works and Utilities. The payment vouchers for that sum are 20 AC, 21, 22, 23, and 24. The county government of Kiambu, the second one, the second payment, made payment to Testimony Enterprises Limited in respect of work done for a total sum of 88,454,222. These are reflected in the 4 payment vouchers, 25, 26, 27, and 28. Mr. Mohammed stated that the total sum paid to Testimony Press Limited on account of the tender for the road construction was a sum of 147,273,555. He also added that besides the payment for that road transport tender, Testimony and Price Limited were paid through contracts and a request for quotation a total sum of 74,216,944.80, as shown by the following payment vouchers: 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 3, 4, 5, 6, 7, 8, 9, and 60. The sums are shown. At the trial, the lead investigator contended then that a sum of 221,499.80 cents was laundered to companies and entities owned by officials of Kiambu County government from the payments under the questioned road project tender and the request for quotations. The investigation prepared the investigators Yes, the investigating officer prepared a flowchart of movement of funds from Kiambu County government to Testimony Enterprise Limited and ultimately to companies owned by Mr. Waititu and Susan, producing evidence as plaintiff exhibit number 146. The flowchart is supported by checks and transfer of funds and payment vouchers. These documents are now producing evidence as exhibit number 96 to 101, 108, and 111. The following documents produced as exhibit were relied upon by the prosecution to support the movement of money. Exhibit number 121, transfer of land to Superior Phone Communications, to Saika2 Developers Limited, the purpose was then stated, to be the transfers to establish payment made by Testimony Enterprise Limited to Saika2 Estate Developers Limited. Transfer was then signed by Director of Superior Phone, Rahab Muyaki, Karoki, and Winnie Wambui. And on behalf of Saika2 Estate Developers, the transfer was signed by Mr. Waititu and Monica. Exhibit 120, sale agreement between Superior Phone Communication Limited as vendor and Saika2 as purchaser. Agreement again signed by Mr. Waititu and Monica. After the conclusion of the investigations, Mohammed recommended the charges preferred by the Director of Prosecutions against the accused person. At the trial, the lead investigator produced evidence corresponded by ESCC, inventories for documents recovered, application for search warrants and orders, specimen signatures and direction of suspect and exhibit memo forms referred to in his evidence. This is the defense case. The former governor of Kiambu, Mr. Waititu, chose to give sole evidence and called Winnie Wangeshi Mainda, alias Elizabeth Wangeshi Mainda, DW2 as his witness. He testified that he was a businessman dealing in land speculation and admitted that Testimony Enterprise Limited and its director, the fourth and fifth accused person, were known to him for over 15 years. It is the defense by first accused person that the fourth accused, Chege, approached him to buy parcels of land, Nairobi Block 105, 8850 and 8851, along the Eastern Bypass, and that the sale price for each parcel was agreed at the sum of 50 million. The first and fourth accused person relied on the sale agreement, which is dated the 3rd of January 2018, producing evidence as for the defense as D1 exhibit number 1. He then used the sale transaction to counter the allegation regarding the monies paid by Testimony Press Limited and the further accused person to Saikatu Estate Developers, Saikatu Estate Developers Limited, and Venue Delta Hotel. He claimed that as at the time of selling the 2 parcels of land to the further accused person, the title deeds had not been processed and that he was unable to transfer the properties because of a caveat that was led by the ESCC. The former governor testified that he justly earned his wealth from businesses and a long political career, where he started as a councillor and rose to the position of a deputy mayor, an MP, and eventually a governor. He also testified that he had served as an assistant minister. It was also the evidence of the first accused person that this case was a result of political witch hunts after he aligned himself with the Tanga political wing during the 2022 general elections. And according to him, this political choice, which he had made, caused him to be charged with the corruption offenses and also to be hounded out of the office of a governor. He attacked the process leading to his impeachment before the Senate, a matter that is not for this court to consider. I won't have to whether the Senate is right or wrong. That one I may not know. I do not have jurisdiction over that. First accused person admitted that Benvenue, the hotel, was part of his business, go on together with his wife Susan, and he explained the impugned transfer of money to Benvenue, the hotel, by stating that the said Chege and his company, Testimony Press Limited, were customers of the hotel. The former governor further stated that his wife owns Lexo Petroleum Jiro Shopping Center and a fuel transportation truck, and that when Chege won the tender in question for the road project, the wife used to supply with fuel. He claimed that the payment made to Benvenue, the hotel, were for oil and petroleum supplied. First accused person also testified that he rented a shop to Charles Chege at the Mibora building, who paid $4 million. First accused, in contrast, the evidence by Rab Muhakaroki, denied that the fourth accused, Charles Chege Mbudia, paid money to Lake Naivasha Resort Limited on his behalf and alleged that Chege was a tenant of Rahab. In the end, he produced in evidence the following document in support of his case. D1, Exhibit 1, the sale agreement D1, Exhibit 2, the title deed D1, Exhibit 2.1, lease D1, Exhibit number 2, C1, power of attorney, D1, Exhibit 3, title deed, D1, Exhibit 3.1, title deed. On cross-examination, first accused admitted that he received the sum of 18,410,500 from Testimony Enterprises Limited, which comprises of 12,410,500 received by Saikatu Estate Developers Limited, and he also admitted that Testimony Enterprises Limited transferred a sum of 7,214,000 to Benvenue Delta Hotel, and in re-examination, he insisted that the sum of 18,410,500 received from Charles Chege and Testimony Enterprises Limited was part payment for the sale price of the parcel of land, the subject of the sale agreement dated 13th of January 2018, then produces exhibit number D, Exhibit 1. And on further cross-examination, Mr. Waititu persisted to assert that he was not aware that Testimony Enterprises Limited had transferred a sum of 6 million to Lake Naivasha Resort. The witness for the first accused, Elizabeth Wangeshi Mainda, testified in support of his case that she had sold to him the 2 parcels of land, 10 5, 88, 50, and 51 along Eastern Bypass, and at the trial, he led on the power of attorney dated 7th of November 2014, donated by children, to sell the plot from which the 2 parcels of land were hived and registered. That power of attorney was D1, Exhibit 2C1. Susan testified that she was married to the first accused person for that 4 years, and that during the subsistence of the marriage, the couple has been running business together. She testified that Testimony Enterprise Limited was a client at our hotel, Benvenue Delta Hotel, and made payment through the hotel account. On cross-examination, she admitted that the business name Benvenue Delta Hotel was jointly owned by herself and the husband. She further testified that Benvenue Hotel was a tenant of Waititu Estate Developers Limited, and on further cross-examination, she confirmed that the business name Benvenue Delta Hotel had received the following payment from Testimony Enterprise Limited and Charles Jege. The funds transfer, 99C1, funds transfer, 99, I think I'll check on that one. I'm not sure whether I marked the one for 2 million. I check on the marking, whether it's 99C1, both of them, I'll check on that. Check 97C4, check 97C5, check 97C, two. There should be 97C. Okay, 97C11. I'll also check on that. Vinyaluka Mwangi Wainya was D3. He admitted that was the Chief Officer Department of Road, Transport, Public Works and Utilities, and endowed with the responsibility of an accounting officer and the IOLA at the Department of Roads, Transport and Public Utilities. He acknowledged that he was familiar with the tender in question and played the following roles: budgeting, preparation of departmental procurement plans, initiating the tender document work, appointment of the tender opening committee, appointment of tender evaluation committee, review of professional opinion, award of tender to testimony, issuing of notification letter to testimony, forwarding acceptance letter for tender to testimony and to the county attorney for preparation of the contract, signing of the contract, which is X number 61, appointing project implementation team led by the engineer, PW15, and then he was the signature of the payment vouchers, being the chief officer for that department, which is borne out by the 7th certificate for a total sum of 147 million. On cross-examination, that accused was referred to the tender bin document, X number 8 at page 29 of 213, section 5, bearing the subheading qualification criteria, and considered that serialization and form of tender were not criteria for the tender in question. Chege supported the evidence of the second accused, Susan Wangari, that he paid a sum of 7,214,000 to Benvenue Delta Hotel for outside catering services and conference facility to train and hold the meeting with the staff. He also supported the defense by first accused, Mr. Waititu, that on 3rd of January 2018, he entered into a sale agreement to purchase parcels of land, Nairobi Block 105, 850 and 851. He then made the following payment to the first accused person, to the first accused person's company, Waititu Estate Developers Limited. The payment of 13th March, 5th October, all those payments. So the above payments are supported by a band of 10 receipts, produced in evidence as D5, exhibit number 41 to 10, and the agreement dated 3rd of January, produced as D5, exhibit number 5. Chege admitted that Rahab Muyaki, the proprietor of Lake Naivasha Resort, was well known to him for over 20 years, and that on 20th of August, he had paid a sum of 6 million to Lake Naivasha Resort as goodwill for shops A and A2 on ground floor of Delta Hotel, which changed to Benvenue Delta Hotel. In order to support this payment, he produced evidence, the receipt D5, Exhibit 3A and B, dated 28 August 2018, issued by family signature. However, on cross-examination, the funds transfer produced as plaintiff X number 97D1 dated 28 August 2018 and plaintiff XB number 97D2 dated 27 September 2018 narrated the purpose of the funds as a refund of a soft loan. Checkers reliance on the receipts D5XB3 A and B unmasked is trickery. Thus, none of these two receipts, D5XB number 3 A and B, both dated 28 August and 2018, could justify the funds transfer for a sum of 3 million dated 27 September 2018, as per plaintiff XB number 97D2, made after the date of the receipts. In my view, the truth on this matter rests with the testimony by the independent witness Rahab Muya Karoki, PW5. I take the view that the narration on the funds transfer was a cover-up on the money trail by Mr. Chega and Mr. Waititu. More so, that accused conduct is a matter of interest to this particular court. It was discreet enough. That's the fourth accused person. That's Chega. His conduct in this matter is of interest to this court. I note that he was discreet enough and avoided to produce these receipts when Rahab was giving testimony. On further cross-examination, Cheka admitted that on 26th of February 2018, he had signed the bin document for the following for testimony in the Press Limited. That's plaintiff X number 9, and attached the following documents. Many of them, they are the question degree certificates, which were held to be forgeries. The sixth witness was fifth accused, Pedro Wangeshimburu, co-director of Testimony Press Limited, wife to Mr. Chege. A brief testimony was that the husband took her to Kiambu County Government offices to sign the contracts, exit number 61. It was a contention that she was not actively involved in the running of Testimony in the Press Limited and on cross-examination. She acknowledged that Testimony in the Press Limited won the tender in question. And on further cross-examination, Beth admitted that on that 1st of May 2018, she had received a sum of 500,000 from the bank account of Testimony Press Limited. That is per plaintiff X number 97B. This to suggest that Beth was both at a personal level deriving benefit from the funds earned by Testimony Enterprises Limited. Party submissions are as follows. Prosecution filed submissions dated 6 November 2024, highlighted by Mr. Monda, Assistant Director of Public Prosecution. Gist of prosecution submission was that 11th accused, Testimony Enterprises Limited, co-owned by 4th accused Chege and 5th accused Beth, was unlawfully awarded by the 3rd accused Junior Luka the tender in question for upgrading various roads in Kiambu County to bituminous standard. Prosecution blamed the 3rd accused for ignoring the professional opinion, XB number 14, by the head of procurement, which had faulted the tender evaluation committee for introducing two new criteria, namely serialization and form of tender in the report produced as XB number 7B, thus giving undue advantage to Testimony Enterprise Limited against the other 4 bidders. In addition, the 3rd accused was faulted for improper use of office to unlawfully confer benefits, which is the award of tender to Testimony Enterprise Limited. The purported win of the Question Road project tender, Testimony Enterprise Limited, was also blamed for the procurement fraud for relying on the false documents which were attached to the bid document, plaintiff X number 9, and unlawfully acquired a sum of 147,274,055.40, the man's public funds from the Kiambu County government. It was submitted that first accused was the duly elected governor by dint of that position and agent of Kiambu County government. Prosecution contended that funds flow charts produced as plaintiff X 146 demonstrate that substantial amount of public funds paid to Testimony Enterprise Limited from the tender in question were ending the account of the 12th accused, Saika 2 Estate Developers Limited and Benvenue Delta Hotel. Prosecution further submitted that the public funds channeled by Testimony Enterprise Limited through Saika 2 Estate Developers Limited Benvenue Delta Hotel and direct funds transfer were used to acquire the property Delta Hotel from Lake Naivasha Resorts. Thus, It was submitted that first accused had acquired an indirect private interest in the public funds paid to Testimony Enterprise Limited. In a rejoinder to the defense raised by first accused person and the second accused person as well as the fourth accused person for the payment made by Testimony Enterprise Limited to Sakatu Estate Developers Limited and Benvenue Del Hotel, prosecution submitted that the evidence by accused person and the evidence relied upon were contradictory and untenable. An example pointed was the power of attorney donated to Elizabeth Longeshi Mainda, DW2, by her children. Produced as D1 Exhibit 2C, registered on 27th of April 2018. Whereas the sale agreement for the purchase of the parcel of land, Block 105, 8850 and 8851 by Mr. Waititu and Chege was entered on that of January 2018. The agreement, you can see the date, shows that the power of attorney came long after doing the agreement. Another example given by the prosecutor was the obvious contradiction on the purpose of the funds, narrating the funds transfer and received relied upon by Mr. Chege in the defense. Lastly, prosecution urged the court to find that the charges against the accused person and the juristic person, that's the companies who approved beyond reasonable doubt. These are the accused person's submissions, which are dated 27th of October 2024. The same highlighted by Mr. Swaka. Thrust of first accused defense and submission of that this case was a result of politics. It was counsel's contention that there were gaps in the prosecution case in view of the decision. In ASEC petition number E003 of 2022, the petition before the High Court was prosecuted by the 6th to the 10th accused person, that's members of the Tender Evaluation Committee, and resorted to their discharge in the present case. Counsel argued that there was no link to connect first accused person with the charges hearing. It was submitted that the prosecution case was based on suspicion, which in law cannot form a basis of conviction. On this proposition, counsel sought to rely on the case of Joan Chebisa versus the Republic. However, in my humble view, this case was neither a matter of circumstantial evidence nor based on suspicion, as was discussed in the analysis of the evidence. Thus, the other case of Brex versus Kipkering Arab Koske and Joan Chebisa stand distinguished and are not applicable to the facts and evidence in the present case. It also further submitted that payments made to Testimony Enterprise Limited by Kiambu government were for works done. And in closing, Mr. Swaka submitted that the accused persons were innocent and that this court to acquit them. Ms. Kimani advocate on behalf of the other accused person adopted submission by Mr. Swaka and the earlier submission which had been tendered to Mr. Okeo at the halftime stage of no case to answer, and that is going to acquit the other accused person too. The issue for determination according to me is whether prosecutors prove the charges against the accused person beyond reasonable doubt. In addressing this issue, I shall now proceed to analyze the prosecution evidence, the defense raised by the accused person and submission under the following headings. The first heading will be on the burden of proof. Second, on the background for the tender in question for upgrading of various gravel roads to bituminous stand in Kiambu County, that procurement process, and award of tender for upgrading of the various gravel roads to bituminous standards, the money trail, the quagmire of conflict of interest and a determination on the charges. So those are the three subheadings that I'll be addressing the determination by this court. This being a criminal trial, it is now settled law that the burden of proof is on the prosecution to prove every element in the charge is beyond reasonable doubt. That's the burden. It is the law that accused person do not have any burden to prove they are innocent no matter the charges. And this principle is well established in the celebrated case of Wilmington versus DPP, 1935 SC 461. That's often quoted locally. It's also trade law that proof beyond reasonable doubt does not mean necessarily proof with certainty. That is as per the decision of Miller versus Minister of Pensions, and I did 47.2 All England Law Report at 372 to 379, decision by one of the distinguished judges in England, Lord Denning. This is the standard of proof that this court will apply in the evaluation of the evidence presented in this case. The onus, again, to discharge that burden of proof rests on the prosecution, as is the law and provision section 107(1) of the Evidence Act. That whoever desires then court to give judgment as to any legal rights or liability, depending on the existence of facts, which one asserts must prove those facts exists. Briefly stated, you alleges must prove. The first heading is on the background of the tender. For a better understanding of this case, it's important to consider the background of the question tender for the roads project. The controverted evidence John Gadigi Mugwe, PW5, a former county executive committee member, in charge of the Department of Road Transport, Public Works and Streets at the Kiambu County government, presents the origin of the idea to use new methods to make roads, which was mooted by the governor in January 2018. He initially undertook the research and became aware of the Road Standard Circular number 1 of 2016, XB number 90C, which was forwarded by the Principal Secretary Minister of Devolution to the Chairman Council of Governors. He also forwarded the circular to sub-county engineers and the direct accused person, the chief officer at the Department of Roads. At the same period, the direct accused was working on the cabinet paper of the new technology in line with the governor's proposal. At the beginning, Engineer Luca forwarded the draft cabinet paper titled Proposed Improvement of County Gravel Road to Bitumen Standard Using the Soil Stabilization to John, PW15, by the email of 29 January 2018, XB number 92. In response, John also made the comment on the draft cabinet paper and brought the email dated 30th of January 2018, plaintiff number 92, to Engineer Luca and Mr. Karanja. And on 30th of January, he wrote the email XB number 94 seeking advice from Martin Jogumbogwa, the cabinet secretary, when the cabinet paper was to be tabled. This was the last time that John heard about the matter, since there was no reply from the cabinet secretary. He was never availed the opportunity to table this cabinet paper before the county executive committee for discussion and approval. Evidence by John is corroborated by Martin Jogumbogwa, that's the cabinet secretary, and supported by the unsigned cabinet paper for proposed improvement of county roads to bitumen standard using soil stabilization, producing evidence XP number 92A. To me, this marked the first start of the question tender, which was advertised and awarded without approval of the county executive committee. It is important to observe that the county executive committee approval was a fundamental stage, forming the initial stage of requisition for the tender on behalf of the resident of Kiambu County, the ultimate beneficiary of the road project, and on whose behalf both the governor and his executive committee were exercising delegated authority. To restate this matter differently, in the absence of the county executive committee approval, requisition, which is a fundamental step in procurement, was skipped. The safeguards then, which had been cautioned in the Ministry Road Circular number 1 of 2016, plaintiff number 90R, were trashed. In the aftermath, that personal interests were then at play. The architects of this criminal scheme and their roles would then be unveiled in the next heading. So I move forward to the next heading, the procurement process and award of tender. Notwithstanding the omission of the table, notwithstanding the omission to table the cabinet paper 92A before the county executive committee for approval, Engineer Luca instructed Engineer Peter Karanja Jenga to PW15 to prepare the bin document, plaintiff XB number 8, in respect of the question road project tender. Next, the tender was advertised. The advertisements confirmed by the adverts contained in the February 2018 and Business Daily of 12 February 2018 produced as Plaintiff X number 3A and B. The primary document of the criteria for the tender was the bin document Plaintiff X number 8, uploaded by the prospective bidders from the Kiambu County Government website, www.kiambu.go.ke. The criteria is related to page 29 of the bid document. And I'll not repeat the criteria again. You'll be able to see it. The other accused, Nyaluka Wainya, admitted the role of the appointing the tender opening committee and the tender evaluation committee. Up to that stage, all seemed well until the tender evaluation committee made its report dated the 5th of February 2018, as per Plaintiff Exhibit number 7. Should be 7B. 7B. Signed by the 6th, 7th, 8th, 9th, and 10th accused persons. Those are the tender evaluation committee that were discharged. The tender evaluation committee members report at page 3 under the subheading responsiveness. Based the evaluation on the 10 criteria which are produced below. I've put in those criteria and be able to see them. And on careful comparison of the bid document, that was the primary document for the tender, exhibit number 8, and the tender committee evaluation report, exhibit number 7B. 2 new criteria were then sneaked in at the tender evaluation stage, that is serialization and form of tender. This led credence to the observation by Dr. Justus Mbundi Kinoti, the head of procurement, in his professional opinion about these 2 criteria. These newly introduced criteria resorted to undue advantage to Testimony Enterprise Limited over the other 4 bidders and was the only successful bidder at the primary evaluation. The star prosecuting witness, Mr. Mbundi, correctly observed that the introduction of the 2 new criteria meant that bidders were evaluated on a new criteria which they were not aware. Grabman of Virginia Luca defense against the charge of abuse of office was that serialization and form of tender were mandatory statutory requirements under the Public Procurement and Asset Disposal Act 2015. This argument is self-defeating and is discredited by the engineer's failure to observe the due diligence in the preparation of the bid document and lack of fairness by disregarding the professional opinion by the head of procurement, which was within his mandate. The head of procurement had recommended a re-evaluation of the tender by the same committee or a different committee in accordance with provision section 46(4)(d) of the Act. This was the opportune moment to correct the anomaly pointed out by the head of procurement. The summary rejection of the professional opinion is contained in the there accused handwritten notes in blue ink bearing the words due procurement process had been followed to the letter. Few issues noted above cannot affect the outcome even after evaluation, and therefore I hereby award the tender to Messrs. Testimony Enterprise Limited, quote, and head of court, words of the accused person, Engineer Lucas. The same was also, these remarks the Dara accused was confirmed by the document examiner, Stephen Yego, as the author of these remarks. It is apparent that Dara accused failing his duty. That's under section 94(3) of the Act, which demands that an accounting officer in making a decision to award a tender shall take into account the views of the head of procurement and assign professional opinion. Instead, Engineer Luca opted for a casual and summary rejection of the professional opinion, XB number 14. In petition number 3, the matter that was before the High Court, the learned judge rightly observed that Engineer Luca was to blame for disregarding the head of procurement professional opinion and awarding the tender, instead of remitting the bin points for re-evaluation according to section 46(4)(d) of the Public Procurement and Asset Disposal Act. In that decision, the learned judge held that to charge the petitioners for doing what was required of them under the law, while not preferring charges against the accounting officer, who approved the tender despite the adverse comment of the head of procurement and without remitting back to the petitioner to address those concerns is an abuse of the court process. I agree with those remarks by the learned judge, but only point out one outstanding factual issue, which with a lot of humility I wish to correct, which was the misapprehension that the accounting officer was not charged, yet indeed the accounting officer was before this court facing charges. That is Engineer Luka. Certainly, the engineer was the responsible accounting officer, and was charged together with the members of the Tender Evaluation Committee in the present case, but under separate counts. Nevertheless, it is my view on the matter before the High Court and the matter before this court, every case must then rest on its facts and circumstances. So I only deal with this particular case on the circumstances and the facts that were presented before me. Provisions of Section 227(1) of the Constitution prescribe the principle to guide state organs and public entities, the procurement of public goods, services, and adverts to a system that is fair, equitable, transparent, and cost-effective. In this case, Engineer Luka went ahead to award the tender to Testimony Press Limited, and in so doing, he sidestepped the constitutional requirement of fairness, equity, transparency, and cost-effectiveness. The mischief of Engineer Luka in awarding the tender to Testimony Press Limited is laid bare by the false academic certificate and letter of recommendation attached to the bid document, plaintiff X number 9. Mr. Chege testified that he was the main director of Testimony Press Limited and signed the bid document X number 9. His signature on the same was confirmed by the document examiner, who is witness number 31. Consequently, the responsibility to prepare the bid document X number 9 for the Testimony Press Limited squarely rested on Mr. Chege. The unchallenged evidence by the prosecution witnesses Kazenya, Albert Evans, Munzimbova, and Dr. Esther Dara Moria established that the academic certificate and the curriculum vitae for the technical staff attached on the bid document by Testimony were forgeries. This meant that Testimony Press Limited lacked qualified professional staff to perform the road construction. The Tender Evaluation Committee and Engineer Luka never exercised due diligence in evaluating the bid document for Testimony Press Limited and awarding the tender. In reality, Testimony Press Limited had flatly failed the preliminary evaluation and stand guilty of fraud in procurement for relying on the forged academic certificates. The other key criterion provided in the bid document, that's plaintiff exhibit number 8, is proof of works of similar magnitude. For Testimony Press Limited, it had attached on its bid document exhibit number 9 a copy of the recommendation letter dated 24th of March 2015, plaintiff exhibit number 67A, purported to have been written by U Chair on behalf of China Wuji Company Limited. The letter and its content are to the effect that Testimony Press Limited was a subcontractor in a contract of rehabilitation to be two-men standard of Suna to Masaka Kienja CE13 project. This misrepresentation was disputed by Luo Zicheng, PW 11, the deputy manager at China Wuji Company Limited. It became then evident that Testimony Press Limited failed on the criterion requiring it to submit document on proof of work of similar magnitude. That's the experienced performance of the road construction works. I have no doubt that the prosecutors established that Testimony Press Limited won the tender in question by deceit and procurement fraud with the aid of Engineer Luka and the Tender Evaluation Committee. In the circumstances, Engineer Luka, the other accused, and Chege, for the accused, joined the ranks of the first two architects of the corrupt scheme, which is the subject of this case. I now proceed to deal with the money trail. The money trail in this case connects the former governor, his wife, and their business entity to the corruption scheme. It is not in contention that Mr. Chege and Beth, on behalf of Testimony Press Limited, signed the contract dated 16th of March 2018, plaintiff X number 61. Engineer Luka signed the contract on behalf of Kiambu County government. The prosecution established that the payment made to Testimony Press Limited in respect of this tender by consistent evidence on payment vouchers tendered by the accounting professionals working at the Department of Finance and the resident engineer for the road construction project. Among these professionals, Faith Njeri Harrison, former Chief Officer in charge of Finance Department, Peter Karanja Jenga, PW15, Senior Superintendent Engineer, Resident Engineer, supervising the road projects, Joseph Kamau Dande, Senior Accountant in the Examination Section of Finance Department, Henry Buruwaweru, former Director Accounting Services and second approver in the Internet Banking System, Anna Njeri, a former Acting Director Accounts and second approver in the Internet Banking System, Jaco Masharia Gadenya, Assistant Director Accounting Service at Finance and Economic Planning Department, the county, a first approver in the Internet Banking System, who mutually corroborated each other on the payments procedures as well as the processing of the payment vouchers paid in favor of Testimony Enterprises Limited. The payment process under the 9 payment vouchers in respect of the tender in question are tabulated in Table 1. We will be able to see the table. And besides the payment from the tender in question, Testimony Enterprises Limited also received payment from the various requests for quotation made in 51 payment vouchers tabulated in Table 2. You'll also see Table 2. In all the above 60 payment vouchers, the signature of the AIE certificate was signed by Engineer Luca. The other accused was the Chief Officer Department of Roads. These payment vouchers originate from the department presided by the same officer. Regarding the tender, Peter Karanja Jenga, the Senior Superintendent Engineer, supervising the road project, testified that 3 interim certificates were raised by the contractor technical officer and himself. In order to confirm that the payments indicated in the 6 payment vouchers were indeed paid by the county government of Kiambu, prosecution then called Lijondi Kihima, a former senior legal officer at Equity Bank, who tendered evidence. The bank account for Testimony Enterprises Limited as exhibit number 97B. Additionally, they also called Leonard Kipseme, PW24, Senior Manager in charge of Client Onboarding and Account Services at Central Bank of Kenya, who produced an evidence the bank statement for Kiambu County Government as exhibit number 116 and as exhibit number 116. The payments to Testimony Enterprises Limited were drawn from the 2 central bank accounts. The payments made to Testimony Enterprises Limited in the 6 payment vouchers are shown in the following table at Table 1. That's the first table. That's a payment received from Kiambu County Government to the Equity Bank account of Testimony for the tender in question. Total sum 147,274,055. The second table showing the payments. These are payments under the request for quotations. Total 85,883,580. Last piece of evidence confirming the payment to Testimony Enterprises Limited is the IFMI supplier details for Testimony Enterprises Limited, XB number 126A, and the invoices 126B, which were retrieved from the IFMI system. In my humble view, prosecution evidence in support of the payment made to Testimony Enterprises Limited for the tender in question and request for quotation is sound and overwhelming. Critical part of this aiding is the movement of funds after the payments into Testimony Enterprises Limited account domiciled at Equity Bank. To entities which are associated with the former governor and his wife, as shown by the 4 flowcharts. We start with the first flowchart from Testimony to Saikatu Estate Developers. You are able to see the checks The other flowchart shows the second one, Testimony movement from Testimony Enterprise Limited account to Lake Naivasha Resort account. The second one, the second flowchart from Testimony to Benvenue Delta Hotel. Then that Testimony to Lake Naivasha. Then the fourth chart, movement from Testimony Enterprise Limited to Charles Chege. Then funds transfers that went to Benvenue Delta Hotel, as well as Saikatu Estate developers. In summary, from these flowcharts, the payment received by Saikatu Developers Limited at Benvenue Delta Hotel from Testimony Enterprise Limited and the fourth accused Charles Chege Budhia, who sources public fund from Kiambu County Government, is shown in table number 3. Table 3. I've summarized all that movement in that particular table. Total 18,410,500. Table 4, payment received by Benvenue Delta Hotel from Equity Bank, account of Testimony, again totaling to 7,214,000. Table 4. So that shows the money trail and where money came from and where it ended. I look at the validity of the contract for this tender. That contract is now exhibit number 61. The procurement process preceding the execution of this contract is tainted by fraud. I've got no doubt about that. I've looked at the definition of fraud under the Black's Law Dictionary, which is knowing misrepresentation of truth or concealable material fact to induce another to act too honest or to her detriment. The first issue that I'll tackle is that Testimony Enterprise Limited won the tender by relying on forged academic certificates, forged CV, and a forged recommendation letter for proof of works of proof of similar works. The attachment to this bid document by Testimony attests to these facts. Indeed, that company lacked qualified personnel and work experience to undertake such a big road project. The second issue on it is that Testimony Limited won the tender by manipulation and procurement fraud perpetrated by Engineer Luka Oyenya and the Tender Evaluation Committee. The inclusion of the new criteria during the tender evaluation to which serialization and form of tender gave Testimony Enterprises undue advantage against the other 4 bidders. From the start, Engineer Luka manipulated the process of procurement contrary to Section 74(1) Roman 1 of the Act by omitting serialization and form of tender in the bid document, plaintiff X number 8, and cunningly in his defense, despite the obvious omission, he alleged that the 2 criterions were mandatory as state requirement under the said Act. The casual disregard of the professional opinion, plaintiff X number 14, by the engineer and the surreptitious authorization to advertise the tender when the cabinet paper exhibit number 1 was not tabled and approved by the county committee speaks volumes on the entire procurement process, which in my view falls short of the constitutional threshold that I've stated under Section 22, under Article 227 of the Constitution. Indeed, the procurement process and award of the tender to Testimony Enterprise Limited, superintended by Engineer Luka, was a mockery of the law. For all intent and purpose, the tender in question was meant to benefit Testimony Enterprise Limited, whose director was Charles Chege, and at the same time, an acquaintance of the governor and his wife. By dint of provision of Section 661, as read with Section 663 of B of the Public Procurement and Asset Disposal Act of 2015, that contract stands to be voidable. It is straight law that a contract procured by fraud is illegal, null and void ab initio. This legal proposition supported by the decision of Blue Shopping Mall Limited by the City Council of Nairobi and 3 others, which had been quoted by the prosecution. In my view, I have no doubt that that contract is illegal, null and void, and I so hold. So the same being voidable is illegal, null and void from its very beginning. I now look at the quagmire of conflict of interest. A keen scrutiny of this case, and I believe it's very important for a country like ours. A keen scrutiny of this case unearths the shadow of conflict of interest. And in my own view, that is the antithesis of good governance. That's where things are getting wrong. Thorough investigation by EACC officers exposed the money trail of public funds paid to Testimony Enterprises Limited from the question tender and the request for quotation, which ended at the doorstep of Waititu Estate Developers Limited. And the Benvenue Delta Hotel. That is shown by the flowcharts 1, 2, 3, and 4, clearly demonstrating the money trail. The end result of the money trail is that Waititu Estate Developers Limited, a company owned by Mr. Waititu, first accused, and the daughter received from Testimony Enterprises Limited at Charles Chegembudia a total sum of 18,410,500. That is shown at table 3 at page table 3. I'm not certain about the page because the font could be changing. In addition, Benvenue Delta Hotel, a business name co-owned by Mr. Waititu and Susan, received from Testimony the sum of 7,214,000, which is shown by table 4. I'm not certain about the page. The page keeps changing because of the font, but the table doesn't change because it derived from the statement and payment vouchers. The defense raised by the first accused person, the second accused person, and fourth accused person failed to account for the checks and funds transfer disbursement made by Testimony Enterprises Limited and its director Charles Chegembudia into the account of Waititu Estate Developers Limited and Benvenue Delta Hotel, as well as Lake Naivasha Resort Limited. In my view, this defense is, although conflicting, at the same time they contain an equivocal admission of business dealings which were ongoing between Testimony Enterprises Limited and the fourth accused person, Charles Chegembudia, on the one part, and Waititu Estate Developers Limited and Benvenue Delta Hotel on the other part. A common version of the defense by first, second, and fourth accused person was that Benvenue Delta Hotel was providing conference facilities, lunch packs, fuel to Testimony Enterprises Limited during the performance of the question tender. This defense by itself is an admission of the complaint conflict of interest. Moreover, the defense by the accused person regarding the services and goods supplied by Benvenue Delta Hotel to Testimony Enterprises Limited is not supported by corresponding documents on the actual transaction. Second line of defense adopted by Mr. Waititu and Chege was an alleged land sale transaction for parcels of land Nairobi Block 105, 88, 50, and 51. While I do not find any fault in the position that Mr. Waititu, position that was taken by the first accused person that he purchased the 2 parcels of land from the witness, Elizabeth Mahinda, the purported sale transaction between first accused and second accused person, and the sale agreement dated that January 2018 produces D1 number 1 lacks credibility. These transactions were at best afterthoughts meant to mislead this court from the truth. The first flaw in the purported agreement is the unexplained contradiction that the power of attorney D1 XB number 2C which permitted Elizabeth to sell the plots, consolidated into the two parcels, is dated 27th April 2018, a date almost 4 months after the agreement dated 3rd of January 2018, D1 Exhibit number 1. Another glaring falsehood in the defense by the first accused and fourth accused is in respect of the sum of 6 million paid by Tesman Press Limited to Lake Naivasha Resort Limited. The truth was told by the independent witness Rab Muyaki Karoki that Chege was making the payment on behalf of Mr. Waititu for the purchase of the property where Delta Hotel was. Now Benvenue Delta Hotel. The receipt producers D5, Exhibit 3, and B were manufactured to suit the accused person's false defense. The receipts are dated 28 August 2018, meant to explain the funds transfer, as well as the receipt dated 28 August 2018, D5, Exhibit number 3B were meant to explain the funds transfer. Producers Exhibit number 97D2, dated 27 September 2018, is a factual example that the accused persons were not telling the truth. You can look at the dates, and then you'll be able to see, honestly, the dates are different. If the funds transfer in September, and you are making receipts even before you do the payment, the funds transfer, now how can that one be correct? In absence of credible account for the monies received by Waititu Estate Developers Limited at the Benvenue Delta Hotel, the only inevitable conclusion that Tesman Press Limited and Mr. Chege were remitting kickbacks to the former governor through his business entities. Constitution has placed a strict divide line for the governor to choose between public trust and business, which could lead to conflict of interest. I hold that friendship, self-enrichment, and business association are no place in public service and governance, which requires self-service, which requires a selfless service. Unfortunately for the governor, on his first term as the governor of Kiambu County government, he failed in his oath of office and allowed personal interest to supersede the public interest to safeguard public funds. He resorted to siphoning public funds into his pockets through the network of companies, Tesman Press Limited, Waititu Estate Developers, and Benvenue Delta Hotel. He thus joined the ranks of the trio and actors behind the covert corruption scheme. Evidently, this tender, and I have no doubt that the involvement of the governor was concealed in a lopsided procurement process and only exposed by the overwhelming evidence on the money trail. These are my determination on the charges. For count number 1. The offense against the first accused person, Venandungu Waititu Babaya, the former governor of Kiambu County, alleged that between 22nd July 2018 and 13 March 2019, he knowingly acquired the sum of 25,624,500 to stop the payments made to Tesman Press Limited for the contract awarded to the said company by county government. Conflict of interest and economic crime governed by Section 42(1), 2, 3, and 4 of the ASECA, which provides conflict of interest if an agent has a direct or indirect private interest in a decision that is privileged to make, the agent is guilty of an offense. If there's the situation in A and the situation in B, and there's 2 and 3, as well as 4. For 48, that's the penal section. In order to make a determination of that charge, the legal definition of the terms public officer and agent are crucial, so as to interpret the element for the offense of conflict of interest. Meaning of an agent is as per Section 38 of ASECA. Agent means a person who in any capacity, whether in public or private sector, is employed or acts for and on behalf of another. Status of the first accused person in the Constitution and the law is defined under the following provisions. Governor is the chief executive of the county as per Article 179(4). Is a state officer as per Article 260. He's also a public officer as per Section 2 of the ASECA and Section 2 of the Public Officers Ethics Act. In absence of statutory definition of the phrase conflict of interest, courts have resorted to the definition provided in the legal dictionary and judicial interpretation. First definition appearing in the Black's Law Dictionary. I'll not read it, you'll be able to see it. The second and definition, judicial interpretation is in the case of Bevin Wanjiro Namu as a National Police Service Commission and another. 2019 EKLR, decision by Justice Mwita. I'll not repeat it. The other definition by Justice Onyego on John Faustin Kinyo as a public 2020 EKLR. It is there. And bear in mind this definition, the phrase conflict of interest in the context of the present case would mean a conflict between public officers' fiduciary duty and his private interests. In applying this interpretation, the key element for the offense of conflict of interest under Section 42(3) of ASECA, which are relevant to this case, are as follows. The accused person is an agent or a public officer of a public body. Accused while an agent or state officer acquires direct or indirect private interest in conflict of his official duty in contract for the public body. Accused while an agent knowing so acquires the direct or indirect private interest in contracts for the public body. And that, I think I'm repeating. And the second element is what forms the mens rea, the guilty mind. Reading from the provision of Section 42(3) of ASECA, and the particular of the offense in count 1 for conflict of interest. For the charge to succeed, prosecutor must establish that the public officer knowingly acquired direct or indirect private interest by receiving benefits in payment made to testimony express limited for contracts awarded by Kiambu County government. In applying these elements of conflict of interest in the present case, it is necessary to prove beyond reasonable doubt that the governor knowingly acquired indirectly a private interest by receiving the sum of 25,624,500 from the payment made to testimony express limited from contracts that were awarded by the Kiambu County government. This is the case because the law under Section 42(3), by its purposive interpretation, prohibits a governor being an agent from harboring personal interest in contracts with this county government. The rationale in the law restricts a governor from holding private interest contracts awarded by his county government to avert the untenable conduct where an elected state officer is unable to objectively discharge his official duties because of the competing direct or indirect private interests. It is the intention of the law that private interest either a public officer from dedicating his whole to serve the people. A public officer must take keen interest in the affairs of the office. The Constitution of Kenya 2010 then envisages a government based on national values and principles of governance as articulated under Article 10. Under the Constitution, public officers are required to adhere to national values and principles of governance, which include good governance, integrity, transparency, and accountability. To mirror the definition, all these definitions that are meant under Section 38 of ASECA to the facts of this case. First accused person, an elected governor, was an agent of the Kiambu County government, which is a public body. The Gazette notices on the election of the first accused person as a governor produced in evidence as Exhibit number 47 attest to these facts. First accused person, once serving as the governor of Kiambu, indirectly through entities like Waititu Estate Developers Limited and Benvenue Delta Hotel, received a total sum of 25,624,500 from Testimony Enterprise Limited and its directors, Charles Chege Budia. Flowchart number 1, 2, 3, and 4, which I've referred above, illustrate the movement of money and payments made to Testimony Enterprises Limited from the road project tender and request for quotation awarded by the Kiambu County government into the account of the entities like Waititu Estate Developers and Benvenue Delta Hotel. Additionally, under Table 1 and 2, I've also manifested a concise tabulation of payments which has raised and paid to Test Enterprises Limited in respect of the road project tender and request for quotations. The source of the funds: movement of money from Kiambu County government to Test Enterprises Limited bank account, and the movement of money from the bank account of Test Enterprises Limited to the entities associated with the government is well supported by the unchallenged evidence, which came from the following areas. 1. Kiambu County Government Central Bank Accounts, bank account of Test Enterprises Limited and Charles Chege Budia, bank account statement of Sekatu Estate Developers Limited, the Benvenue Delta Hotel, testimony of the resident engineer on the road project regarding processing of the payment vouchers and attachments, if me supplier details of Test Enterprises Limited. The defense by the governor and the second accused and the main director of Test Enterprises Limited to explain the reasons of the money set by the entities like Sekatu Estate Developers Limited and the Benvenue Delta Hotel as well as like Naivasha Resort Limited lacks credibility. I found the defense to be self-incriminating, bearing admission that Benvenue Delta Hotel, a business name, co-owned by the government's wife, was directly trading in the Test Enterprises Limited by supplying oil, petroleum products, and offering conference and catering services. Indeed, by this admission, and considering that Benvenue Delta Hotel is a business name, then the governor was directly trading its county government. The governor has failed to rebut prosecution of overwhelming evidence that through the entities Sekatu Estate Developers and Benvenue Delta Hotel indirectly received a sum of 25,625,500. This sum includes the Kenya shillings 6 million paid by Test Enterprises Limited to Lake Naivasha Resort Limited. The governor then corrupt intent is manifested in the fraudulent procurement process and award of tender for the road project to Test Enterprises Limited. Again, the opaque advertisement of the tender for the road project without county executive committee approval and the covert remittances of money from the bank account of Test Enterprises Limited to bank account of the entity Sekatu Estate Developers and Benvenue Delta Hotel. In this case, the conflict of interest was committed with the full knowledge of the first accused person, and that cannot be excused. The inevitable conclusion that first accused person, you are liable in count number 1 for conflict of interest by acquiring an indirect personal interest in the accumulated sum of 25,624,500 from the Test Enterprises Limited, which was channeled through your company and business name during your tenure as the governor of Kiambu County government. Thus, this case is a classic example of conflict of interest and debunks the much hyped theory by the accused person of political witch hunt. So I didn't see any politics. Figures don't lie. There are no politics in this. Count number 2, dealing with section which involves dealing with suspect property contrary to section 47.1 as the read with section 47.2a, the penal section 48 of ASECA. Charge against first accused person's company Sekatu Estate Developers for dealing with suspect property, receiving the sum of 12,410,500, while aware that the money was acquired from Kiambu County government through corrupt conduct. The offense under section 47 of ASECA provides a person who deals with property that he believes or has a reason to believe was acquired in the course of or as a result of corrupt conduct is guilty of an offense. And you can see the situations under A, B, the definition of corrupt conduct under 2, in the case of Republic vs. Alfred Moreiri, by Just Majanja is then worse. He dealt with that situation and held as follows: not proof. They believe that property was acquired in a course of or as a result of corrupt conduct. The prosecutor must establish that the underlying conduct that constituting corruption or economic crime which can be imputed to the accused person. Now, reading from the provision section 47(1) and 2, and in applying the judicial interpretation by Justice Majanja, the element for the offense of dealing with suspect property relevant to this case are as follows: 1, proof of receiving the suspect property by accused person; 2, proof of corrupt conduct; and 3, belief or reason to believe that the suspect property was acquired from corrupt conduct. The suspect property in present case is the sum of 12,410,500 received by Waititu Estate Developers from Tesman Enterprise Limited. First element of receiving the sum of 12,410,500 is clearly established by the bank account of the two companies and payment vouchers analyzed in the money flow chart. One, I'm not sure about the pages because of change of the forms, but the flow chart that shows that flow chart number 1 and 4, and then the tabulated payment shown in the table number 5 below. So I've created a that table showing that sum. You can see the figure adds up to 12,410,500. You can see the checks transfer produces exhibit. Second element of the offense, proof of corrupt conduct, is borne out by the conflict of interest established count number 1 against the first accused person. I shall rely on the reasoning that I've stated in count number 1 on the conflict of interest. Last element for the offense, proof that accused said reason to believe that by receiving that sum he had acquired from Kiambu County government is borne out by the similar reason that constitutes the mens rea for the offense in count number 1, the one for conflict of interest. I reiterate that conflict of interest committed in the full knowledge of the first accused person is established by the fraudulent procurement process and the award of tender for the road project to Tesman Enterprise Limited. I've also established that there was opaqueness in the advertisement for the tender without the county executive committee approval, and also again the covert remittance of money from Tesman Enterprise Limited and Waititu Estate Developers Limited. In the premises, again I hold that prosecutors established the offense in count number 2 against the former governor and his company, that's Waititu Estate Developers Limited. Count 3, dealing with suspect property, under provision section 47, as read with 47(2), against the former governor and Waititu Estate Developers, facing charge of dealing with suspect property, the sum of 6 million to be paid by Tesman Enterprise Limited to Lake Naivasha Resort Limited as part payment for the purchase price of the property where Delta Hotel stood, having no reason to believe that the money was acquired from the county government of Kiambu. Now, the property was subject to the landscape transaction that went on between the former governor and Rahab, the owner of Lake Naivasha Resort Limited. Rahab testified that for the accused person, that Mr. Chege through Tesman Enterprise Limited paid a sum of 6 million to Lake Naivasha Resort Limited on behalf of the former governor. The money trade and the two funds transfer of the suspect money, that's the 6 million shown by the flow chart number 3. I'm not very sure about the page. So look at flow chart 3 as well as the table 6 below. In the evaluation of the evidence with regard to the funds transferred to Lake Naivasha Resort Limited, I believe that the independent testimony Rahab and rejects the conflict evidence by the further accused person, Mr. Chege. This table 6, which elaborates flow chart number 3. You can see the checks the two funds transfer for 3 million each, and the corresponding debts, summing up to 6 million. By parity of my reasoning, count number 2, I'm convinced beyond doubt that the sum of 6 million of property acquired by former government Sekatu Estate Developers Limited from Tesco Enterprise Limited out of conflict of interest, subject of count number 1. I will adopt the reasoning count 2 on the element of corrupt conduct and reason to believe that the money was acquired as a result of corrupt conduct. I'll go to count 4, dealing with suspect property. Again, charge against first accused person and second accused person, trading as Benvenue Delta Hotel for jointly receiving the sum of 7,214,000 from Tesco Enterprise Limited, which money emanates from the account of Kiambu. Transaction by Tesco Enterprise Limited Benvenue Delta Hotel are demonstrated by the flowchart number 2. Again, I'm not sure about the pages. Flowcharts 2 and 3. Look at the 2 flowcharts. I'm not sure about the pages. As well as table number 2. I've shown you table number 2. It is evident that the governor and his wife, through their registered business name, Benvenue Delta Hotel, had received the sum of 7,214,000. The money was sourced from payment for the question tender for the road project and request for quotation, which had been awarded by the county government of Kiambu. Defense by the governor and his wife, and Chegen, the director of Tesco Enterprise Limited, in an attempt to account for the suspect money's unworth of credit. And unfortunately, I found that defense incriminates them for conflict of interest. Both accused persons, in their respective own defense, raised the absurd theory that Benvenue Delta Hotel was supplying Tesco Enterprise Limited with oil and petroleum products used in the suspect road project tender. In addition, accused person testified that Benvenue Delta Hotel was paid by Tesco Enterprise Limited for conference facilities, accommodation, and lunch packs. This defense was a factual admission that the governor and the wife were trading with the Tesco Enterprise Limited and by extension, the county government of Kiambu. From this defense, Benvenue Delta Hotel was a supplier of Tesco Enterprise Limited, a contractor awarded the road project tender and request for quotation by the Kiambu county government. Be that as it may, accused persons were also unable to account for the payment received by Benvenue Delta Hotel from Tesco Enterprise Limited. Therefore, there is no doubt that the sum of 7,214,000 was public funds and was acquired from Kiambu County government through corrupt conduct evidenced by the conflict of interest perpetrated by the former governor in count number 1. A look at the particulars of the offense shows that the period when the alleged offense was committed is stated as that 1st October 2018 to that of January 2018. However, this transaction, the subject of the charge, based on the fund transfer and checks which were disclosed to the accused person at the pre-trial stage, have established that the period that 1st October 2018 to 18 January have established that the period is that 1st October 2018 to 18th of January 2019. Prosecution while placing lines on the case of Elias, Emmanuel, and 2 others versus Republic submitted that the variance on the dates pointed out above were curable under provision section 214.2 as well as 318.2 of the CPC. On this argument, I take the view that the irregularity did not render the charge effective and was curable. Given that a disclosure of the bank statement indicated the question transactions had been made to the accused person, no prejudice then was the question to them. I've looked at the Court of Appeal, I rely on the Court of Appeal case of Peter Ngure Mwangi versus Republic, where the court excused a defect in the charge sheet, where the name of the complainant was erroneously typed. Similarly, I shall adopt reasoning count number 2 above on the elements of the offense under count 4 and find that the charge in count 4 has also been proved against the accused persons. Count 5, abuse of office, contrary to provision 46 as read with 48. Charge against fourth accused person, Luka Mwangi Wainya, alias Lucas. Accused was the chief engineer, roads, transport, public works, and Pleads government. Is faced with corrupt offense of abuse of office for improperly conferring a benefit by awarding the contract in tender, in the question road tender within Kiambu County, worth the sum of 5,198,328.20 to Testimony Enterprises. It is a prosecution contention that Testimony Limited was regularly procured as a contract for the road project tender. Prosecutor was able to establish that accused person, Engineer Luca, was the chief officer. Regarding the tender, he bore the following responsibilities: preparing the draft cabinet paper, appointing the tender opening committee, appointment of the tender evaluation committee, review of the professional opinion, award of tender, signing of the contract, signing of commencement of works letter, signing notification, appointment of resident engineer. At the department was the AIE holder, so the person to sign the AIE certificate on the payment vouchers. Prosecution led evidence that accused person superintended over the process of procurement and award of the question tender, which was marred by irregularities and fraud. The end result was an award of tender for the road project to Testimony Enterprises Limited, an unqualified bidder. Prosecuting case against that accused person is supported by sound evidence implicating that accused person for the following deliberate shortcoming in the performance of his official responsibilities. 1. That accused person in cahoots with the first accused person secretly advertised and produced in evidence the report, exhibit number 63, as well as Dr. Esther Dara Moria, PW10, Director of Academic Affairs of JQR, to produce in evidence the report, exhibit number 65. It is a matter of satire that the date on the 4th degree certificate of Evan Joroge Gombi, exhibit 62D, bears the graduation date, the 7th of December 2017. This one implied that the graduation ceremony by the University of Nairobi, a public university, was being held on a Sunday. Honestly, we don't hold graduations on a Sunday. On the same matter, PW7 and PW8, whose copies of CV and certificates were attached on the bid document, plaintiff exhibit number 9 vehemently denied that they were employees of Testimony Enterprises Limited. On cross-examination, Charles Chegembudia admitted that he signed the bid document, plaintiff exhibit number 9, on 26th of February 2018, but was tongue-tied to account for the forged certificate and the employment of PW7 and PW8. His blame on Juan Kazungu for compiling the bid document does not change matters. Responsibility for this bid document, plaintiff exhibit number 9 rests with the 4th accused person and the 5th accused person being the directors of Testimony Enterprises Limited, who mispresented facts to the effect that the 4th degree certificate were genuine academic credentials issued by the university. The 4th degree certificates were relied upon by the tender evaluation committee to score Testimony Enterprises Limited on the criteria that the company had qualified as skilled personnel to handle the road project. On account of this fact, I find that accused persons are guilty as charged under that particular count. Count number 8, engaged in a fraudulent practice in procurement, again against Mr. Chege and Beth, this time round forging a recommendation letter purported written by China Wuji Company. The bid document, exhibit number 8, advertised by Kiambu County government for that road project tender, further required the prospective bidders to attach in their bid proof of works of similar magnitude. Now, looking at the bid, exhibit number 9, which was submitted by Testimony Enterprises Limited, and signed by Mr. Chege. The same attached a copy of a recommendation letter dated 24th of March 2015 at page 257A. The letter was disputed by the Deputy Director of China Wuji Company, who produced the letter. That's exhibit number 7A. Also on the same matter, The bid was supported by a notification of award for the rehabilitation to bituminous standard of Suna Masara Kienja C3 road project. The letter of recommendation attached the bids Exhibit number 9 and the notification of award led to the rehabilitation of the Suna Masara Kienja project at a cost of 615,728,300 turned out to be an outright misrepresentation of fact in the procurement process. Unfortunately, this misrepresentation was relied upon by the Tender Evaluation Committee in the report XB 7B to score and find that Testimony Enterprises Limited was responsive on the criterion that the firm had proof of work of similar magnitude, that the experience for the work. The simple truth is that Testimony Enterprises Limited was not a subcontractor of China Wunji Company Limited. In the road project for the rehabilitation of Suna Masara Kienja C3 project. If at all the Tender Evaluation Committee and the other accused person exercise due diligence in the procurement process, then this company, Testimony Enterprises Limited, would not have passed these primary criteria. Accordingly, I find that accused person then are guilty as charged. That's for that particular count number 8. Count number 9, against Charles Chegambudia and Bedo Angesh Mboro, together with Testimony Enterprises Limited, charged with fraudulent acquisition of the sum of 147,247,055 and 40 cents from the Kiambu County government with respect to the question road project tender. Offense of fraudulent acquisition of public property is created by Section 45(1) of ASECA. The law provides that in protection of public property and revenue, a person will be guilty of an offense if that person fraudulently or otherwise unlawfully acquires public property or a public service or benefit, while a public officer means an officer, employee, member of public body, including one. Okay, that the latter part is not important, but you can see how the offense is created. It is no longer in dispute that Testimony Limited received the sum of Kenya shilling 147,274,055 and 40 cents after the fraudulent tender process and award. The contract dated 16 March 2016, exhibit number 61, executed by the directors of Testimony Enterprises Limited and the former chief officer, Transport, Public Works, is vitiated by procurement, fraud, and conflict of interest. In law, the contract is illegal, null and void. Consequently, all payments received by the Testimony Enterprises Limited meant to perpetrate the procurement, fraud, and conflict of interest amounts to fraudulent acquisition of public property. Proof of the payment is clearly stamped in the transaction at table number 1. I've shown you table number 1. For the pages, I'm not very sure. The transaction are reflected in Equity Bank Limited account for the company. Produced as plaintiff exhibit number 97B and the Central Bank of Kenya statement for Kiambu County government exhibit number 116 for the two accounts. The couple, Chege and Beth, in defense readily admitted being director of Testimony Enterprises Limited, and they were also signatories of Testimony Enterprises Limited bank account, where they questioned payments were made. In spite of this admission, fifth accused claimed that she was not actively involved in the running of the company. However, on cross-examination, the couple considered that they signed the contract for the road project, producing evidence exhibit number 16. In the circumstances, the couple then stand liable for the criminal act of their company. I've looked at section 63 of the Penal Code, which provides where an offense committed by any company or other body, corporate, or by any other society, association, or body, or persons. Every person charged with or concerned or acting in the control management of that, or the affairs of that particular company shall be guilty of that offense and liable to be punished accordingly unless it is proved by such person that through no act or omission on his part. So that provision shows us how to deal with the juristic persons. On knowing the evidence placed before me, I I hold that there is sufficient evidence to support the charge of unlawful acquisition of public property against Desmond Enterprise Limited and its directors as envisaged by Section 63 of the Penal Code. I therefore find the command directors guilty as charged. Now, I'll deal together 11 and 12. I'll address them together on the offenses of money laundering conduct provision section 3A and 1 as read 16 of Pokamla. The subject matter of these counts is the total sum of money which Desmond Enterprise Limited and its main director, Chegen, and transferred by checks and funds transferred to the bank account of Saika 2 estate developers, Benvenue, as well as Lake Naivasha Resort. The same money forms the subject of count number 1, 2, 3, 4, 5, 7, 8, and 9 above, founded on ASECA and the Public Procurement and Asset Disposal Act. The offenses in count number 10, 11, and 12 are brought under provision section 3 of Pokamla, which gives us the definition of money laundering. I placed emphasis on A, and that's an agreement or against any arrangement or transaction in which anyone in connection with that property, whether that agreement, arrangement, transaction is legally enforceable or not. I've also looked at B1, the aspect of concealing. I'll be guided by the decision of Republic as a Director of Public Prosecution and another expert, Patrick Ogola Onyango, and 8 others. Decision by Justice Oguto, as he then was, where he made an in-depth analysis of the legal framework of the law and the elements for the offense of money laundering under Section 3 of Pokamla. A key observation on the decision is the scope of Section 3 of Pokamla, where the learned judge held as follows. Section 3 of Pokamla outlines the offense of money laundering as may be committed by third parties. It is not for the prosecution of those who launder on behalf of others. It is intended, in my view, to help the state to catch up with person in the course of their business or otherwise facilitate money laundering by or on behalf of others, and especially the originators of the crime. The language relating to the physical act is wide and must have been deliberate, so legislated. Section 3 imposes a subjective obligation on the accused person. The physical acts of which a person may be accused of are clear, entering or engaging in an arrangement in connection with the property which forms or is part of process of crime leads to criminal liability under Pokamla. Likewise, performing an acts, whether independent with others, with a view to concealing or remove the property to form or is part of the process of crime, or with a view to enabling or assisting the originator of the crime to avoid prosecution, also leads to criminal liability. The offense is, however, not complete in the absence of the subjective. The person who commits the physical acts must also known or ought to reasonably have known that the property is or forms part of the process of crime. Clearly, therefore, the engagement or arrangement, which is the basis of the charge of money laundering, must actually result in an identified individual or entity receiving or retaining property, which at the time of the arrangement or engagement was or formed part of the criminal property. It is for the prosecutor to prove not only these actors' reas, but also the mens rea. Prosecutor must prove that the accused was involved in an engagement or arrangement under Section 3 of Pokamla. The prosecutor must also prove knowledge or facts showing that the accused must be deemed to have known that the property received, whether money or otherwise, was part of or constituted process of crime. It is for the prosecutor to show the prosecutor benefits of a criminal act, that they are process of crime. In summary, thus, prosecutor need to prove that accused entered into or became concerned in an engagement or arrangement which he knew or to have known facilitated the acquisition, retention, and use or control of criminal property, proceed of crime, by or on behalf of another person, the effect of which will conceal or disguise the source of the proceed. Now, my observations are as follows. The phrase originator and third party as applied in this decision by Justice Oguto a significant definition of the offense of money laundering. And the offense of money laundering was defined in the decision targets the prosecution of that parties who knowingly are involved in the engagement or arrangement to acquire, retain or use or control proceeds of crime with an intention to conceal or disguise its source. The accused person before me fits in the definition of originators of corruption offenses. That's the predicate offense. The subject charge is count number 1, 2, 3, 4, 5, 7, 8, and 9 under SECA and the Public Procurement and Assets Disposal Act. As such, the materials placed before me only disclose the offense under these two statutes. For the prosecution to charge the accused person again under Pokamla for the offense of money laundering. In my own view, and for purpose of fairness, I found that one was oppressive and unjustified. For this reason that I'll find accused persons, you are not guilty of the charges under count number 10, 11, and 12, the offense of money laundering. In the final results, having painstakingly evaluated the evidence presented by the parties and on careful consideration of the submissions, I am convinced beyond reasonable doubt that the prosecutor proved the charge against the accused person in the following counts. Count 1, first accused person, guilty. Count 2, first accused person and SECA 2 estate developers of the accused person, guilty. Count 3, first accused person and SECA 2 estate developers limited, guilty. Count 4, first accused person and second accused person and Benvenio Delta Hotel, guilty. Count 5, third accused persons, guilty. Count 7, Charles Chegembudia, guilty. With the fifth accused and Testimony Enterprises Limited, fifth and 11th accused person. Count 8, fourth accused person, fifth accused person, 11th accused persons, guilty. Count 9, fourth accused person and fifth accused person, 11th accused persons, guilty. With regard for those counts guilty and convicted as charged, with regard to the offense of money laundering, contrary to section 311 in Roman as read with 16 of Pokamla, and account 10, 11, 13, I find the accused persons not guilty and acquit them under provision of section 215 of the CPC. That brings me to the end of this judgment. Would I propose? We take a break still of 35 or 45 minutes. If we can utilize the 45 minutes, I'll endeavor to print a copy of the judgment for you first to internalize within that given time. I'll also give you time, you speak to your client. Then we come back, correct? We get the addresses on the record for the accused person from the prosecution, followed by the mitigation. And I'll propose, if you can save time, well and good, we'll be able to finish. If you are able to give me up to, you spend almost 1 hour on that, I really appreciate. And I'll be able to come back to you with the sentences. That is one. I don't want to preempt the defense, but it will be almost not my practice. I release people on bond once I've convicted. I'll go and sentence, then pay your sentence and you go home. Or you go to the High Court if it is stayed well and good. So let us not spend time on that. Let's see the best that we are able to do. And I'm also alive to the governor, the issue of the title deeds. I personally undertook to ensure that they are safe, correct? I'll also endeavor. Once we come back, you can organize that custody about the same, correct? Yes, because it's good we take care of property, irrespective of what we have said. Is that one agreed? Yeah, so we can use this time, it's good. We go for health break. You can also take your lunch, but meanwhile, accused person shall remain in custody. I don't know who is in charge of the court orderlies. Mr. John. Can I move down?
Sentencing serves a number of objectives, which includes punishment of the offender, punishment of the offender for the criminal conduct, deterring the offender from committing future or similar offenses, as well as to discourage the public from committing similar offenses. In determining the sentence to be meted out to the accused persons, the court ought to be guided by relevant statutes and provisions of law that create the offense, mitigating factors, and aggravating factors against each of the accused persons. Your Honor, even though the accused persons before court are first offenders, we call upon this court to consider the following aggravating factors in coming up with the sentence. The first one is the nature and seriousness of the offense which the accused persons were charged with. Your Honor, the accused persons have been charged with corruption-related offenses, and the amounts involved are huge. And as a result of their conduct, the county government of Kiambu lost a huge sum of money. Your Honor, we pray that in meting out the sentence against them, you consider the principle of proportionality, to match the gravity of the offense. The gravity of the offense that they have been convicted with. Your Honor, the second aggravating factor that we wish this court to rely on is the impact of the offense to the society. Your Honor, corruption is a cancer that is killing the economy of Kenya, whose effects are wide and include the fact that corruption is stifling the economic progress of this country. It is distorting markets. It is stifling the economic progress of this country. It is distorting markets and discouraging investors from investing in this country.
The second one?
Distorting markets and discouraging investors. Your Honor, it is also undermining the public trust and it is because of the impact of this offense that we are asking this court to mete out strict sentence to the accused persons. You know, wish this court to also consider the fact that the first accused person was, at the time when these offenses were being committed, was the governor of the county government of Kiambu. And the third accused person was a chief officer of roads, transport, and public utilities at the county. They held public offices and had positions of great responsibility and public trust. They were custodians of public funds, and their positions required them to have high levels of integrity, but they failed by engaging in corrupt conduct. Their acts are a breach of public trust. Their acts and erode the public trust in governance. Testimony Enterprises and its directors that is the fourth and fifth accused person, intentionally and deliberately submitted false information and documents to the county government of Kiambu, which led to the award of tender to them. By submitting forged documents and misrepresenting themselves,
Jonah, perhaps if you could get an indication of how long
documents they deprived legitimate and qualified bidders a fair chance to compete, thus distorting the procurement process. Their fraudulent actions resulted into the award of a multi-million shilling tender to an unqualified entity leading to a loss of public funds that was paid to them from the county government of Kiambu, amounting to 147 million 274,055 shillings. 147 million 274,055 shillings. The contract they entered into with Kiambu County was obtained by fraud. These aggravating factors that we implore this court against the accused persons to serve as a deterrent to any person thinking of engaging in any corrupt conduct. We pray that the court be guided by the following provisions. In sentencing the accused person, with regards to count 1, 2, 3, 4, and 9, and I'll repeat.
Yes. 1, 2, 3, 4, and 9.
Yes, Your Honor. Yes. We pray that the court be guided by Section 48 of a SECA, which provides that if a person is convicted of an offense under that part for which the accused persons have been convicted, the person shall be liable to a fine not exceeding 1 million and imprisonment for a term not exceeding 10 years or to both, and a mandatory fine if as a result of the conduct that constituted the offense the person received or caused a loss of fund. Your Honor, in this case Section 48.2 provides that the mandatory fine shall be 2 times the amount of benefit or loss. With regards to count 4, yes, Your Honor. Your Honor, we submit that in this case there was a quantifiable benefit to the accused person or loss, and therefore Section 48.2 should apply. With regards to, and that will also apply to count 5, the actions of the third accused person led to a quantifiable benefit to testimony enterprises. And therefore, we pray that the court be guided by Section 177 of the PPADA. 177 of the PPADA, that is Section 177. Yes, Your Honor. So, Your Honor, in this case, because of the seriousness of the offense, we'll be praying for both a fine and imprisonment. All the accused persons. And we'll be praying for the court to apply Section 64 of ASECA, which disqualifies any person convicted of a corruption or economic offense from being elected or appointed as a public officer for 10 years after conviction. We will also be relying on 2 authorities. That is High Court ASEC is 001. Unfortunately, I do not have a copy, but they are both on EKLR. But I can make yes. High Court ASEC is 001 of 2022.
Maybe
of 2022. David Gidaiga and 2 others versus Republic, and High Court ASEC number 1.
Yeah, maybe you're right, with very kind permission.
Yes, it is
Just a quick one.
Yeah.
Okay, I wanted that clarification.
ASEC, High Court ASEC number 1 of 2022. Francis Zuriels Muturi versus Republic. Francis Zuriels Muturi. Zuriels versus Republic, where in both cases the accused persons were sentenced by the lower court. Yes, and the High Court upheld both. Yes, that is all, Your Honor.
And I'll be doing my mitigation based on that headline that their husband and wife, and that whatever sentence that is meted upon each or both of them, Your Honor, will have extremely deep ramifications on the dependents, who are basically their children, family, and equally those whom they support on a day-to-day, week-to-week basis. And of course, that includes their parents, their siblings, and the many employees who work under them, Your Honor. First and foremost, Your Honor, we've been informed that they're first-time offenders. Indeed, we confirm so. And I wish to underscore the fact that my client is extremely, extremely remorseful. We do not wish to belabor the court on that. And we do not wish to take the matter equally lightly. But they're extremely remorseful. We want the court to really know that. Further, Your Honor, you've seen their conduct right from the inception of this matter when we took plea. And we came for pre-trials before you, Your Honor. They've always attended this court with extreme respect, honor. And when they failed, there have been some good explanation. They have been very cooperative, Your Honor. And not only now, even at the time of investigations. Your Honor, these two families, and especially the first office, through this matter, Your Honor, as you read in your judgment, you did allude the fact that he was duly elected. And we all know what that costs in terms of resources, time, and investment. But he didn't finish his term, Your Honor. Halfway, been hounded out of office and thrown back to the streets, Your Honor. Him and his family have gone through a lot of mud. Your Honor, for me, that is enough punishment. Father, Your Honor, we did actually inform the court prior and even now that at the point of arrest and investigations, a lot of documents, personal effects were actually carted away from my client's house, place of work as well. And the absence of those documents, which again we said were never actually used here, have left a big gap in his relations, in his work, in his trade, in his business, in his relations with his clients, in his business deals. He alluded that he's a businessman, the court is aware. And generally, in his family way of life. And I want the court to actually know that the first and the second accused person, Your Honor, have really suffered as a result of this matter. And that cuts across to the fourth and the fifth, Your Honor. They've been dragged literally through the mud because of their company testimony. I'd wish the court to, and I wish to adopt what my learned senior Jenga just expressed to you, that this was not a ghost project at all. In fact, witnesses came, competent witnesses for the prosecution, have indicated that work was done. And even they confessed that the money paid was not in tandem with the work done. The rest of the arguments, we can leave them for appeal. The documents that were used to procure the work, same documents which this honorable court has struck out, that we can leave for appeal, Your Honor. But what is very clear before you today as we mitigate is the testimony of the prosecution witnesses themselves that indeed work was done, and they still owe testimony huge amounts of money. The court will take judicial notice equally that at times servicing such projects takes a lot of investment. You are the fourth accused person went through hellfire to raise money to finance this particular tender. Sorry, Your Honor? Yeah, I'm saying he went through hellfire just to raise money to be able to fund this tender. And I believe in our testimony, we did, and many other financial institutions where he approached. Some of them are not even documented. Others were monies they borrowed from friends and relatives on gentleman's agreement that once paid, he has suffered. As a result of testimony and indulgence in this matter, he has suffered financially, resourcefully. And again, I wish to reiterate that him and the fifth accused person, being husband and wife, are both in the dock. And their parents, both of them are in the dock. Husband and wife, fourth and fifth. I've said their parents, despite the fact that I've already said they've suffered immensely for this work. Their parents, they are sole providers for their family and for their children. And the dependents are looking up to them in terms of provision and directions in life. Again, I said, these are their children. And if you extend it, their parents as well, who are aging and who are sickly. Given the fifth accused, as the court heard, did not participate in the day-to-day running of testimony, enterprises. And she was candid enough with the court. She was extremely honest to say that I was called to append signatures on this tender. But thereafter, Your Honor, I didn't know the workings, that my wife was more or less a silent or a dormant director. She did not participate in the day-to-day. I was actively involved. I was the one on the front line. The banks, documents from banks were adduced, Your Honor, to demonstrate that she's not a signatory to anything. And so just wish the court to also underscore the fact that much as she's been convicted, her role in this particular and sad saga was extremely minimal to zero, Your Honor. I wish to also refer the court to the objectives of sentencing. Why do we sentence? You do not sentence to destroy a livelihood, to destroy a generation, or to kill or maim, which is rehabilitative in nature. And which gives hope and strength even to the convicted persons, that there will be a tomorrow where things can be better and our dependents can have a life. The court should consider the responsibilities that a convicted person or an offender has towards other third persons who are vulnerable, basically. And I've said we have two pairs of parents in the dock. If the court was to take them away forever or to give them such heavy sentences, John and many other people who are not connected to this will be collateral damage. They will suffer the process. Others who are not a part of this but who are dependents will be prejudiced by the fact that their parents, their providers are languishing in jail, serving long custodial sentences, or unable to raise monies imposed on them as fines. We don't need such a scenario. Sentence can make a statement in a rehabilitated manner. Your Honor, the law provides that where there's an option of an uncustodial sentence and the offense is before you. I'll wait for you. The sentencing directives, the new sentencing directives, to provide that where there's an option of an uncustodial sentence, as it is in our current case, the court should embrace that as opposed to a custodial sentence. And the court can be guided by the criminal history of any offender or any other to sentencing the four accused persons whom I'm representing. Your Honor, I also wish you to understand that there are companies which have been equally raising a living for them. I've been embroiled in this case and I've been convicted. So we are talking about a scenario, Your Honor, where not only the director of a company is affected, but also the company itself. Both the farm and the crops are indisposed. They are unable to generate a living or wealth. And so as you sentence, Your Honor, consider the fact that these are companies that nobody has actually said are fraudulent in any manner. They were registered or initiated through or for purposes of fraud. These are companies that have been working transparently until they were hit by this matter. The directors are the same who are in the dock. And so if the Honorable Court does not exercise restraint, then it will be punishing the convicts twice. And it will be a big burden. I wish the court to consider that. If given an opportunity, Your Honor, to walk out of this gates free, because the court has the power to discharge them conditionally or unconditionally. My clients have a word to the court that what transpired leading to this offense and leading to this prosecution will never, ever, ever happen again as long as they are living and breathing. They again reiterate they are sorry. They ask for the forgiveness of God and you, and they implore the Honorable Court to raise mercy and to tamper mercy with justice. And to give them a second chance to life. They are on their knees. They have lost everything that they ever had. Political office, companies, money, wealth. They're in the mud. They're on their knees. They're flat on the ground. The court should not do anything further to break the small will of the small heart that is still remaining to live tomorrow. Give them that chance to rise up again. I thank you.
So, no, they are not. Yes. Yes. Yes, I say it was in excess of, I think, $1 billion or something.
So if you give it, I appreciate it. I don't want to.
Yes. Actually, I was going through this authority. This is where money was actually money was not.
This one there was no money.
Sorry?
This one there was no money.
No, Your Honor, is what we say, work was done.
But I respect
It's not like this.
But I respect us.
Okay, much.
No, Your Honor.
The many years that we have been in this trial, and I appreciate when Mr. Swaka you say, you just go sit down. I look at this very little, and I know how also difficult it is for the accused persons. I'm not in a position to allow you to continue. Somehow, you may be able, with your own prayers, to appreciate what I'll be able to do so that some are intertwined. It appears some offenses, the same sums are duplicated in the same offense. So really not a question of just looking at the count, then I say per ASECA 1 and ASECA 2, I do this and that. I think I'll create an injustice and I don't want to do that. I still want to uphold fairness to you. So I really, with a lot of respect, then you can just bear with that day, and I'll also count the day when I'm doing the sentence. It will not be lost as I do the sentence. And that one, I think it's something that I've told you with all due fairness and deep down in my heart, taking consideration the heavy mitigation that Council you have said. You have talked about companies, you have talked about employees, you have talked about the families. Honestly, you can bet I'll really create chaos and go contrary to what Council JM and Swaka you have told me. The objective have more chances up there, correct? Yeah, so just appreciate that. At the
because they came without anything, their children are still, they just came. So there's somewhere where the people can give them clothes and food, something that's what we're doing. Since we'll be back here maybe tomorrow.
the in charge of prosecution, maybe I can have a word with him. I can have a word with him. Who is in charge of... I hear him, Council. So let me just have a word with who is in charge. Who is in charge? Who is the inspector who is in charge? Can just come. I want us to be objective. Maybe Mr. Swak and Mr. JM, I wish I could come down there, but we just come and probably face. Just come in conference, because I don't want to raise up and go. If it is possible, we can go to a police station, but I really want to visit you councils in April, the way you appear. Even at midnight, I can cancel that and go down for council. And that's what I'm going to do. If there is any problem, I know bullshit, I know it. We have a problem. Yes, then you will let the process just run. That one at least I've done out of your respect to people. Not the way I respect you people. You are not just doing this one. It's continuity. And you have colleagues. So we can adjust about them. Maybe correct? Yeah.
Are they able to ensure that
That's it. Assure. Maybe they are not there.
But tomorrow they'll be prepared now with those things.
Instead of doing I know the sacrifice I can. So I have no problem. It's within me. I bear the responsibility. But don't let me down. Correct? Yeah, please. You tell her, just even go and talk to the politician right now. Then you come back and give us that assurance. You just go. Then you can also press upon it. Just wait. You can just wait. Between the two of us, me personally, I'm not correct. And even that, I will not put it to the court that I want that. Yes. Okay, very much you can. Governor, you got my communication. You got my communication. We obeyed. Okay. Can we agree on the time? Correct? Yeah. So the issue of the titles, we'll do it tomorrow. We'll ensure that by morning you have retrieved them, correct? Then you can return certified copies here, so that I don't want to finish up the matter. Then I go and later hear those titles have been missed. I don't want to carry that kind of a bad story. We'll reconvene tomorrow for the sentencing at 10:30. Accused person will be remanded in custody make a disclosure on whether they demanded for reasons that discussed with councils as well as the prosecution council.
Leo mnanipiga picha yani
Sudan dia ba. Ndio shikilia hapo.
Tosha.
tunapiga stop.
Aya, stop.
Good night. Tunamwambia good night baba. Tunamwambia baba.